Cell phones are off. Very good for my person. Thank you, maybe see. Yes. I'm sorry.
Okay, we're gonna take Monroe County case up first here. This is Monroe Circuit Court, meeting in special session here today by agreement of the parties. Commonwealth versus, we'll say Robels, 23 CR 00050. Are you Mr. Robels?
Yeah.
Good morning. You have a social security number?
Yeah.
What are the last four digits?
4313.
What's your year of birth?
2000.
Okay. A motion has been tendered that says you wish to enter plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
This is plea freely and voluntarily given.
Yeah.
Okay. You're the same person that we just identified in 23 CR 0050. Is that correct?
Yes, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you? Do you believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution before I can accept a plea. I'm gonna go over these rights at the end. I'm gonna ask you to understand them, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor. Right to appeal this matter to higher court if you lose, and right to require comment proving unreasonable doubt that you're guilty of the charges against you. Understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, which you'll hear in a few minutes, but I may apply a range of sentence by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll wait for pre-sentence investigation report on my probation and parole. But in the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea for the trial. You understand that?
Yes, sir.
Okay. Move to the left a little bit again. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to the charge of assault first degree, the defendant shall receive a sentence of 15 years. Upon a plea of guilty to the amended charge of manslaughter first degree, the defendant shall receive a sentence of 15 years. Upon a plea of guilty to the charge of wanton endangerment first degree, 3 counts, the defendant shall receive a sentence of 5 years on each count to run consecutively for a total of 15 years. Upon a plea of guilty to charge of wanton endangerment first degree, 1 count, the defendant shall receive a sentence of 2 years. The 15-year sentence for the charge of assault first degree and the 15-year sentence for the amended charge of manslaughter first degree shall run concurrently for a total of 15 years. The 15-year sentence for the wanton endangerment first degree, 3 counts, and the 2-year sentence for wanton endangerment first degree, 1 count, shall run consecutively for a total of 17 years. The wanton endangerment having been committed before July 15th of 2024, thus the parties being in agreement that the 4 counts of wanton endangerment shall be calculated at 20% parole eligibility. The 15 and the 17-year sentences shall run consecutively for a total of 32 years to serve. The defendant shall receive credit for time served. The Commonwealth opposes probation and shock probation. After final sentencing of the defendant, in this case, the Commonwealth agrees to dismiss Commonwealth versus Fatima Robles, Monroe indictment number 24 CR 15 with prejudice. The defendant's wallet, ID, and any cell phones belonging to the defendant or co-defendant shall be released to a representative of the defendants and or the respective owner. The 2017 white Chevrolet Silverado pickup truck with VIN number 3GCPCREC1HD 433959 shall be released to the owner at Fatima Robles after final sentencing. The defendant shall forfeit the green and black with gray steel magazine with 21 rounds of AP 300, rounds green .300 mag, semi-automatic, Palmetto State Defense PA 15 rifle with serial number PA 129597 shall be forfeited to Kentucky State Police Post 15 and disposed of in accordance with the laws of the Commonwealth and the Kentucky State Police Post 15. Forfeiture order submitted with this plea. The defendant agrees to have any and all other evidence in the above solved case forfeited and destroyed in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Was that your understanding of the recommendation?
Yes, sir.
Okay. Are you pleading guilty because you did commit the acts charged in the indictment as amended now? Is that correct?
Yes, sir.
You doing so of your own free will?
Yes, sir.
Knowing your constitutional rights have explained to you, is it still your desire to give up those rights and plead guilty and allow the court to fix your punishment?
Yes, sir.
You understand that after any of this plea, if you have future convictions of felony, the range of penalties will be increased under persistent felony offender law.
Yes, sir.
Okay, now is that your signature?
Yeah.
Now, I'll accept an agreement, order pre-sentence investigation for it. It looks like the next rule day's the 14th, but I would doubt very seriously where you get a pre-sentence investigation.
I've already said no.
Okay, so, the next September, the Tuesday, September 16th.
Yes,
Will be a sentence. Okay, well, thank you very much. One more Monroe County case. Commonwealth versus David Wood. Commonwealth versus David Wood. This is 25 CR 0017 for sentencing. Good morning.
Good
Are
morning.
you David Wood?
Yes, sir.
This is Monroe Circuit Court Case 25 CR 0017. Mr. Wood, were you born in 1981?
Yes, sir.
Last four digits of social security number 2810.
Yes.
Okay, you're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation?
Yes,
Is
sir.
it substantially correct?
Yes.
Counselor, is there any reason this gentleman should not be sentenced today?
There's not, Your
On
Honor.
a plea of guilty possession of controlled substance, first degree, second offense, defendant shall receive since 1 year probated appointing or supervised. The 1 year shall earn consecutively to the Monroe Circuit Court indictment number 19 CR 00108. Defendants agreed that all the evidence in the above style case is ordered or destroyed according to the laws of the Commonwealth of Kentucky. He shall have a gainful employment. What, do you even know what the court cost is?
It's almost. Well.
What's your court cost here?
155.
How much? If you give you a break, you do the 155. Do you know, you need some time to pay that?
I'm quite happy to that.
Go to the circuit clerk's office over here. Y'all can't sit payment here, can you? So you have to go to Monroe County to pay it, okay?
Yes, sir.
Okay, thank you very much. And you need to meet with a probation and parole officer at some juncture.
Oh, I've already talked to him. I talked to him yesterday. I've already.
He's on active already and he knows to meet with his
So
officer.
just
over there.
continue.
Yeah.
Great. Thank you very much.
Have a great day.
You too. Commonwealth versus Brian Gross. It's Commonwealth versus Brian Gross, 24 CR 0041, 24 CR 0058. Are you Brian Gross?
Yes, sir.
Good morning. Were you born in 1985?
Yes, sir.
Last four digits, social security number 2218.
Yes, sir.
What does the Commonwealth have?
We have a misdemeanor plea.
Okay. Motion's been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is the plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 24 CR 0041 and 24 CR 0058?
Yes, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
If you review the evidence Commonwealth has against you, believe you're fully informed about the case.
Yes, sir.
If you understand that you do not have to enter a guilty plea, that you have certain rights under the Kentucky United States Constitution before I can accept a plea, I need to go over those rights and I'll ask if you understand. You're right, not to testify against yourself. No one can make you say anything, right to speak, trial, but jury, right to be represented by counsel at your jury trial, right to confront and prosecute all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor. And have process issued to compel their attendance. You have the right to appeal this matter to higher court if you lose, and the right to apply the Commonwealth without a reasonable doubt that you're guilty of the charge. You understand that by entering the plea that you give up those rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence by law. I don't have to accept it. In the event that I do not accept the recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to the jury trial. What is the Commonwealth's recommendation, Ms. Gordon Anderson?
Yes, Your Honor. Upon a plea of guilty to possession of drug paraphernalia, the defendant shall receive a sentence of 12 months, probated for 2 years, supervised. The 12-month sentence shall run concurrently with Clinton indictment number 24 CR 31. And the defendant agrees to have any and all evidence in the above style case disposed of in accordance with the laws of the Commonwealth and the holding agency.
Is that your understanding of the agreement?
Yes, sir.
See, are you entering this plea because you did commit the acts in the indictment as amended that?
Yes, sir.
You're doing so your own plea will?
Yes, sir.
Know your constitutional rights and previously explained to you, but still you desire to give up the rights and allow the court to fix your punishment. Is that your signature on the document there?
Yes, sir.
I'll accept the agreement now. The probation, you need to meet with probation and parole here. Either one of those two fine folks over
I have a question, please, sir.
there. Yeah,
I'm serving a 3-year sentence right now, and that was to be run concurrent with this 3 years. And I'm eligible for shock. I've never filed for it. I've got 6 months, almost 6 months in on this 3 years. I'm in MRT.
you'll need to talk to your attorney for the file motion.
I'm for shock.
If you're eligible. You go over there. Nicholas Cooper. Cromwell versus Nicholas Cooper. 25 CR 0034. Are you Nicholas Cooper?
Yes, sir.
Good morning. Were you born in 1988?
Yes, sir.
Last 4 digits, social security number 8854. That's correct. You're here for a pre-trial conference, goes to Commonwealth.
Do you have a felony plea, Your Honor?
Motion has been, I've just been informed that a motion has been tendered, says you wish to enter guilty plea today. Is that correct?
Correct.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is it plea free and voluntarily given?
Yes.
Are you the same individual you just identified in 25 CR 0034? Is your judgment impaired today?
No, sir.
Can you discuss this charge with your attorney? Are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
I am.
You understand that you do not have to, guilty plea today. You have certain rights under the Kentucky United States Constitution.
Yes, sir.
Before I can accept the plea, I need to know that you understand those rights, and I will ask you at the end if you do, okay? You have a right not to testify against yourself. No one can say, you have a right to speak trial, but you're represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Your right to produce evidence, your right to call witnesses your favorite. Your right to appeal this matter to higher court if you lose, and right to apply the Commonwealth to prevent reason doubt that you're guilty of charges against you. Understand that by entering guilty plea, that you give up all those rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's let me stay there just for a second. So, I may consider the Commonwealth's recommendation, but I may apply the legislature by law. I don't have to accept the recommendation. Prior to accepting any recommendation, I'll order a pre-sentence investigation report to be done by probation and parole. After reviewing that, if I decide to impose a harsher punishment, you agree to, you have a right to withdraw your plea. Understand?
Yes, sir.
Now you move over here. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to tampering with physical evidence, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 3 years. The 5-year sentence and the 3-year sentence shall run consecutively for a total of 8 years, probated for 5 years, supervised. This 8-year sentence shall run consecutively with Russell indictment number 24 CR 78. The defendant shall enter and complete a long-term rehab determined by and scheduled through DPA and agreed upon by the Commonwealth. The defendant is currently incarcerated and has served approximately 4 months and shall receive credit for this time served. The defendant shall remain in custody until after final sentencing in the morning of the bed date. Probation and parole shall transport the defendant to the rehab facility. The defendant agrees to have any and all evidence in the above style case disposed of in accordance with the laws of the Commonwealth and the holding agency.
Is that your understanding of the agreement?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
Doing so of your own free will.
Yes, sir.
Knowing your constitutional rights to examine, is it still your desire to give up those rights and guiltily allow the court to fix your punishment?
Yes, sir.
You understand that agreeing this plea any future conviction can be enhanced and persistent felony offender law. You understand? Is
Yes,
that
sir.
your signature? I'll accept the agreement or a pre-sentence investigation report to be done. Have scheduling done on September the 11th. Okay, thank you very much. David Sullivan. Commonwealth versus David Sullivan, 23 CR 0044. Are you David Sullivan? Good morning. You born in 1980? Yes. Last 4 digits, social security number 6949? Yes. You're here for the pretrial conference today. What's the Commonwealth have to say?
Or I had just been informed right before the court started, but I believe it's gonna have to be evaluated by KCPC.
Yes, that's correct, Your Honor.
It's in an order.
Yes.
What is the underlying charge?
It was a traffic incident. He had an episode and wrecked into a car, allegedly, police car.
We didn't allegedly wreck into the police car. What did wreck into the police car?
They reckoned to me,
Yeah, there was a wreck.
yeah.
It was a record.
It's just wanting to dangerous fleeing and evading and criminal mischief.
So is it gonna be one of these, online evaluations or what?
Yeah,
Did you make a plea offer on them?
We did, yes.
after speaking with Mr. Sullivan, I think that a KCPC evaluation would be,
Okay. Okay. He knows it'll delay the
Yes.
situation, okay. Okay, well, I'll sign an order, get evaluation. Commonwealth versus Antonio Velasquez. This is not one. The interpreter, are you on the line? See where it says.
Good morning, Your Honor.
Okay, will you turn your camera on so you grace us with your presence?
I've been trying, but it won't let me. Let me try again.
There you go. Thank you so much. Madam Interpreter, you raise your right hand. You solemnly swear or affirm that you're qualified to interpret in the courts of the Commonwealth of Kentucky.
Yes, Your Honor.
Okay, thank you. Ms. Velasquez, I have an interpreter on the line. You see her there?
Señor Velázquez, tengo un intérprete en línea, ¿lo ve?
Sí.
Okay.
Yes.
This is 18 CR 006, Commonwealth of Kentucky versus Antonio Velasquez.
Esta es la causa 18-0006. La Fiscalía en contra de Antonio Velázquez.
Were you born in 1969?
¿Usted nació en 1969?
Sí.
Last four digits, social security number 4401.
Los últimos dígitos de su número de seguro social son 4401?
Sí.
Yes.
What does the Commonwealth have to say in this case?
¿Qué dice la Fiscalía de esta causa?
We have a felony plea.
Okay.
Tenemos una declaración de un cargo de delito mayor, felony.
A motion has been tendered that says you wish to enter a guilty plea today. Is that correct?
Se ingresó un pedimento diciendo que usted desea ingresar una declaración de culpable el día de hoy. ¿Es eso correcto?
Sí.
Yes.
Are you currently under the influence of drugs or alcohol?
¿Está en este momento bajo los efectos de alcohol o drogas?
No, no,
Is this
No.
plea, is this plea freely and voluntarily given?
¿Usted está haciendo esta declaración libre y voluntariamente hoy?
sí,
Yes.
Are you the same individual we just identified in 18 CR 0006?
¿Es usted el mismo individuo que acabamos de identificar en la causa 18 CR 0006?
sí,
Yes.
Is your judgment impaired today?
¿Es su buen juicio? ¿Tiene alguna dificultad o impedimento el día de hoy?
no, no, pero ¿puedo hacer una pregunta?
No, but can I ask a question?
Yes, yes.
Sí.
Sí, bueno, disculpe por insistir, ya le dije al abogado, pero por si acaso si hubiera una oportunidad de que se pudiera, haber pues eso le digo, bajo fianza.
Espérame. Well, I'm sorry I'm insisting on this. I already asked the attorney. Is there any possibility on their bond?
I spoke with him about this, Your Honor.
You what?
I spoke with him about the bond situation, told him he was entering in a plea today.
Well, this is not a bond hearing, this is a plea. And we'll take.
Señor,
Go ahead.
esta no es una audiencia de hablar de la fianza, esta es una audiencia de declaración.
I don't know what the plea is going to be. It's new to me. That's
Todo
between you and the Commonwealth. I'll only find out today and then we'll take a look at your situation.
No sé de qué se va no sé yo cómo se va a declarar usted. Es nuevo para mí de qué se va a declarar. Y luego eso tiene que ver entre usted y su abogado de cómo se va a declarar el día de hoy.
Ok, está bien.
Okay, that's fine.
Have you discussed these charges with your attorney and are you satisfied with his advice?
¿Ha hablado usted de estos cargos con su abogado y está satisfecho con el consejo de él?
Está bien.
That's fine.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Usted revisó las pruebas que tiene la fiscalía en contra de usted. ¿Está usted completamente informado acerca de su causa?
Sí,
Yes.
You do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. I need to know that you understand those rights before I can accept a plea.
Usted no tiene que declararse culpable el día de hoy. Usted tiene derechos bajo las leyes de Kentucky y bajo la Constitución de los Estados Unidos y yo quiero asegurarme que usted entiende esos derechos.
I'm going to go over those rights and at the end, I'm going to ask you if you understand them.
Voy a leer esos derechos y al final le voy a preguntar si los entendió.
está bien.
You have the right
That's
not
right.
to you have the right not to testify. No one can make you say anything.
Usted tiene derecho a no dar una declaración. Nadie puede obligarlo a decir ninguna cosa.
You have a right to a speedy trial and to be represented by counsel at that trial.
Tiene derecho a un juicio rápido y derecho a que lo represente un abogado en ese juicio.
You have the right to confront and cross-examine all witnesses called to testify against you.
Tiene derecho a carear y contrainterrogar a todo testigo que declare en su contra.
You have the right to produce evidence and to call witnesses in your favor.
Tiene derecho a mostrar pruebas y traer testigos a su favor.
You have a right to appeal this matter to a higher court if you lose.
Tiene derecho a apelar esta causa a un tribunal de mayor instancia.
You have a right to require the Commonwealth to prove on a reasonable doubt that you're guilty of the charges against you.
Usted tiene derecho a que la fiscalía tenga que comprobar más allá de una duda razonable que usted es culpable de los cargos que se le imputan.
But in your plea today, do you understand that you're giving up those rights?
Al ingresar una declaración el día de hoy, ¿entiende usted que está renunciando a esos derechos?
You understand that?
¿Entiende eso?
Sí,
Yes.
Pardon me. I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided in the law. I don't have to accept the recommendation.
Yo puedo considerar la recomendación de la fiscalía y también puedo aplicar una de acuerdo de la que dice la ley. Yo no estoy obligado a aceptar la recomendación de ellos.
Prior to accepting the recommendation, I will await a pre-sentence investigation report done by probation and Plea.
Antes de aceptar la declaración, yo reviso el informe previo a la condena.
In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and go to trial.
En caso de que yo no acepte la recomendación y le imponga una condena más grave, usted tiene derecho a retirar su declaración e ir a un juicio.
What is the Commonwealth's recommendation?
¿Cuál es la recomendación de la fiscalía?
Upon a plea of guilty to incest, a Class B felony, the defendant shall
You need
receive.
to hold up on her interpret.
Okay.
Al declararse culpable, si se declara culpable del cargo de incesto, un delito mayor de clase B,
The defendant shall receive a sentence of 10 years to serve.
el acusado recibirá una condena de 10 años en la cárcel, en la prisión.
The Commonwealth opposes probation and shock probation.
La fiscalía se opone a la libertad condicional y a la libertad condicional por impresión.
The defendant shall have no contact with the victims.
El acusado no debe tener ningún contacto con las víctimas.
The defendant agrees to have any and all evidence in the above styled cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
El acusado está de acuerdo en entregar toda o descartar cualquier que sea mostrado por las leyes de Kentucky y otras agencias.
Is that your understanding of the Commonwealth's recommendation?
¿Es eso lo que usted entendió de la recomendación que le hizo la fiscalía?
sí,
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment as amended now?
Usted se está declarando culpable porque usted cometió el delito que se imputa en la acusación formal.
sí,
Yes.
Are you doing so of your own free will?
Usted lo está haciendo de su libre voluntad.
sí,
Yes.
Nor your constitutional rights have explained to still your desire to proceed with your plea and allow the court to fix your punishment.
Usted entendió los derechos constitucionales y aún así usted quiere permitirle al juez que le dicte cuál es la penalización.
sí,
Yes.
You understand after entering this plea, any future convictions could be enhanced under the persistent felony offender law.
Entiende que si es cualquiera que es hallado culpable, si es hallado culpable otra vez, cualquier cargo será agravado por bajo las leyes.
está bien.
That's
Yeah.
fine.
Is that your signature on the document?
Es esa su firma en ese documento.
Sí,
I'll
Yes.
I'll accept the agreement, order a pre-sentence investigation report, and schedule a sentencing on October the 9th, because there'll have to be a sexual offender report done on this. At that time, we'll consider any motions you have for probation and that sort of thing. Okay?
Can you let him know that we will give a Spanish PSI to the jail for him to complete? And the PSI investigator will report to the jail to complete it with him.
The PSI is going to be in Spanish.
Yes, we will send a Spanish copy to the jail for him to complete for us.
Ok. El juez dice, yo ordeno recibo el acuerdo que usted ha hecho y ordeno que se haga el informe previo a la condena. Se dictará la condena el día 9 de octubre, registrado como un tribunal, criminal convicto por delitos sexuales. Y luego se va a abordar el pedimento que ha hecho de libertad condicional y otras cosas. Ella dice, y eso dice el juez, la señora dice que se le enviará a la cárcel el informe previo a la condena porque se tiene que llenarlo y que se le llevará en español también.
Okay,
Está bien.
thank you.
That's fine. Thank you.
¿Todo?
Thank you. Wesley Stockton.
Yes, es todo. May the interpreter be
Yes, you may be
dismiss you.
excused. Thank you for your cooperation and help. You have a blessed day.
My pleasure, Your Honor. Have a blessed day.
Commonwealth versus Wesley Stockton, 24 CR 0086. Are you Wesley Stockton?
Yes, sir.
Born in 1984.
Yes, sir.
Last four digits, social security number 4085.
Yes, sir.
What's the Commonwealth have to say?
Your Honor, we've made an offer.
Move over this way, sir.
We've made an offer, but I don't think we've been able to reach an agreement, so we're ready to set it for trial.
What's the charge?
Torture, cruelty to an animal.
1 day trial, probably.
I believe so.
Are you ready for trial? I mean, I said in very short order. How many witnesses to Commonwealth have?
Maybe we can-
Less than five.
What?
Less than 5 witnesses.
Are you ready for trial?
yes.
We could do it, 15th of August, next Friday.
Well,
We have negotiation manual. One of us could be available.
I would like to be there for the negotiation.
Do what?
I would like to be there for the negotiation.
It's helpful.
It is.
So the negotiation day is here or coming?
Not really.
What about Friday, the 29th? Yeah.
If that works for me, Your Honor.
Well, the Robels case is over, we have that entire week. Let's think of that.
Yeah.
Let's look at the 26th. It's Tuesday.
Seriously.
Okay.
Okay.
And Mr. Stockton, today's your day. If you want to enter a plea, all right. Trial by jury, but after today, there's no plea, you understand this?
What does that mean?
Okay, let's go, Colton Abston.
The
Okay. I don't need to bring him back here.
I'm sorry.
Zoom, okay, we'll just do it.
Your Honor, I'm sorry, one last thing with Wesley Stockton. We'd like to talk about potentially amending his bond.
Do what? No. Yeah. You need to file a bond motion.
Okay, thank you, Your Honor.
Tyler Eminette. Tyler Eminette. Motion to revoke bond. What's the Commonwealth know about that?
Your Honor, our motion was based on his failure to appear.
Is there a warrant out for him? And I need to put him in NCIC and make the notation to be held without bond. Michael Ash, it says in custody in Tennessee, is what it says.
He's still in, I checked this morning, Judge, he's still in Tennessee.
You know, what's he doing held on down?
He got new charges when he was arrested on the probation violation warrant.
Yeah, I don't know what they are. Probably possession or something, right? We got a hold on him, right? Take
Yes.
privilege, okay. Victor Barnes. Commonwealth versus Victor Barnes, 25 CR 0059. Are you Victor Barnes?
Yes, Ron.
Were you born in 1985?
Yes, Ron.
Last four digits, social security number 6457.
Yes,
You
Ron.
represented by public advocacy in district court, public defender.
Yeah.
Okay, I'll continue that appointment. You're here today for the purpose of arraignment. This is your lawyer here. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with driving on suspended operator's license and possession of controlled substance and first degree methamphetamine. You know what those charges are, correct? Counsel, you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pre-trial motions.
Yes, Your Honor.
Signing the reciprocal discovery order, sir, that requires the Commonwealth to provide your attorney with information to help prepare for your defense. What is the negotiation day?
September the 4th.
You should be here on September the 4th at 9 a.m. for negotiation, and your next court date is on September the 11th. Both of those are conditions of your bond.
Thank you, Your Honor.
Yeah. Dina Bell. Deanna or Dina Bell. So motion to forfeit. Have y'all received any objection to that?
I don't believe so.
Okay, I'll go ahead and hear it.
No objection.
Clifton Crater, Carter, Clifton Carter, it's Apple. Clifton Carter,
We've got an agreed order, Your Honor, to tender. We're just going to be withdrawing our motion.
withdrawing the motion.
Yes.
Edward Daly. He's here. Edward Daly.
He's here.
Are you Edward Daly?
Yeah, I'm Edward Daly.
Good morning. You born in 1951?
I think it's.
Last four digits, social security number 2842.
Yeah.
Okay, you're here on 22 CR 0013 on a probation revocation.
Yes, Your Honor, we filed this motion because Mr. Daly had failed to be paying restitution. I think he owes about $175. We're willing to hold our motion right now in abeyance and give him some time. to see
What's
if
the
he can
total
pay.
amount he owes?
$175.
It's the total.
Mhm.
You got $175 with you today, man?
No, I have 20.
Well, I don't want to take your last 20. When can you pay the $175?
When can I pay it?
When can you pay it?
Well, I rented me an apartment
No,
down
I'm not asking what apartment that you're renting or anything.
there, but
Let me tell you something I'm gonna do.
when do I need that?
You need to pay that to the clerk's office, the
It's $175.
$175 by September the 11th.
Okay,
Okay, now that gives you over a month to
Plus
pay it,
fees.
okay?
okay, I can,
Plus fees and
Just the court fees, whatever the court.
whatever the court fees are on top of the 175.
I'm waiving those.
Okay.
I'm giving you a break. You pay it by September 11th, it's $175. If you don't, bring your toothbrush and your comb and everything with you and go to jail, okay?
okay,
Okay, thank you.
okay,
You do that now, man, okay?
okay,
Okay, thank you.
okay, I will.
Okay. Derek Garing.
Thank you.
Commonwealth versus Derek Garing. 25 CR 0015. You're here for sentencing. Mitchell, are you Derek Garing?
Yes, sir.
Born 1986. 83, okay, that was a misprint here, and last four digits, social security number 3165. Is that right?
3645.
Three what?
3165.
3165.
6531. My bad.
What are the last four digits of your social security number?
3165.
Okay, that's what I have.
My bad.
Have you ever sentencing? Have you had an opportunity to go over the pre-sentence investigation report?
Yes, sir.
Is it substantially correct, sir?
Yes.
Okay, is there any reason still should not be sentenced today?
No, Your Honor.
On plead guilty to theft and lawful taking of disposition more than 1,000, but less than 10,000, two counts, the defendant shall receive a sentence of 5 years on each count. You run concurrently for a total of 5 years. The defendant shall pay restitution in the amount of $8,200 with 5% clerk's fee. Should be paid monthly with rate $150. First payment being done 30 days from today. Supervised probation shall continue until the restitution and fees are paid in full. Restitution dispersed to John Joseph Hancock, $7,000, and Carl Winterick, $1,200. Via restitution order submitted to the plea. Monthly restitution payment shall be dispersed equally between the two victims. And what's the court cost?
155.
In addition to that, the court costs of $155. You need some time to pay that.
I've got the restitution in my pockets.
He's got the $150 payment today.
Okay, there's a court cost in addition to that. How much again?
155.
$155. You need some time to pay that court cost.
Yeah, give me a day or two.
Do what?
Yeah, give me a
Well, I'm
day.
gonna give you more than a day or two. Just tell me, yes, I need more
Yes, sir.
time.
Yes, sir.
So I'm gonna let you pay that at $30 a month. Okay, so you make your restitution payment plus $30 a month till you pay the $155.
Sorry,
That payment will be due 30 days from today. Okay? You meet the probation for all. Michael Key. Commonwealth versus Michael Keith, 20 CR 0023 for sentencing. You are Michael Keith. Good morning. Born in 1980.
Yes, sir.
Last four digits, social security number 2969, you represent Mr. Cross. You had an opportunity to look at the pre-sentence investigation report. Is it substantially correct? Mr. Cross, is there any reason this gentleman should not be sentenced?
No, Your Honor, we're ready to proceed.
On the plea, the defendant shall receive 5 years, probated for 5 years. probation shall be supervised if the defendant resides inside the Commonwealth and unsupervised if it resides outside the Commonwealth. Defendant shall pay restitution in the amount of $500 within 30 days from today, subject to 5% clerk's fee. And what's the court cost?
$155.
Plus $155. And you need some time on the $155?
I do, sir.
Okay. So you pay I'll just say that you pay the entire $655 plus the 5% on the other within 30 days, okay? I'll give you some time. Thank you very much.
Thank you.
Megan Kennedy. Says in treatment. What's that mean?
They're supposed to zoom in today, believe it or not.
Megan Kennedy. You need to call them and see if they've got the Zoom invitation.
Okay, I'll give you a call.
Jayen Longwell. Is that how you say your name, Jayen? You're here today for the purpose of arraignment. I got Mr. Cross with you. You have the right to remain silent. Anything you say could be used against you. So the grand jury of Clinton County is returning an indictment charging the failure to signal, operating a motor vehicle under the influence, possession of drug paraphernalia, possession of legend drug, and possession of controlled substance. First degree, first offense. You understand what those charges are?
Yes, sir.
Okay. You acknowledge the identity of your client, Mr. Cross, received indictment, wait formal reading and arraignment, interpleading not guilty, reserving all pretrial motions.
Yes, Your Honor.
Does the Commonwealth, are any tests still out? Do you have any chemical tests or anything that's still out?
No.
Okay, I'm signing a reciprocal discovery order of the young lady that will apply the Commonwealth to give Mr. Cross the information that they have to help you prepare your defense. You'll have to be back here on September the 4th at 9 a.m. for a negotiation day and September the 11th, your next court date. Both of them are conditioned to your bond, okay?
Your Honor, is it the 11th or the 16th? I heard a couple of dates on September motion.
September the 11th,
The 11th, okay,
yeah, September the 4th,
that's fine.
negotiation day, okay?
Okay, thank you.
Jimmy Massingale. Commonwealth versus Jimmy Massingale, 25 CR 0045. Are you Jimmy Massingale?
Yes, sir.
Good morning.
No,
You born in 1972.
yes,
Last four digits of social security number 6814.
yes.
We're here for a pretrial conference.
I believe Your Honor, we're ready to set all date.
Yes.
What's the charge?
Forensic, correct?
You made an offer, didn't you?
We have.
That trial that we said a few minutes ago, that animal cruelty, shouldn't take all day, should it? Okay, never mind, this is more complicated than I thought.
Okay.
What about the 15th of August? That was your negotiation day. I'm sorry, it's still your negotiation day. What about August 29th?
I can do that.
The only issue we may have, but we'll find out soon, is that it involves employees of the hospital, so we just need to coordinate with them to make sure that they all. And for every both, they're all over. So as long as they can all be present.
No, that'd be present with subpoenas. Okay,
Thank you.
Seth Roberts. Seth Roberts. Seth Roberts here.
Yes, sir.
Come up to take it with Seth Roberts. 25 CR 0035. You are Seth Roberts. Good morning. You were born in 1993.
Yes,
Last four digits, social security number 0026.
yes,
You're here for arraignment. Do you have an attorney?
no, sir.
Did you have one in district court?
No, sir.
Did you go to district court?
No, but I'm
Is
aware.
this a direct submission case?
Flagrant non-support.
Okay. Well, for the purpose of arraignment, I will appoint the public defender then. Can you afford a lawyer?
Not right now.
Yeah, well, let her interview you. Go back in there. She'll interview you, see if you can get appointed. April Russell.
Yes.
Can you turn the camera on?
Yeah, it's not letting me. The host has to ask you to start your video.
Are you April Russell? Are you April Russell?
Yes.
Where are you? Why aren't you here today?
I'm in treatment, at the Cumberland Hope Center.
She one of your clients?
I believe so,
Yeah, it's not good enough for me while she's not here today, if she's in treatment. Was there agreement with the Commonwealth for her not to be here today?
No.
So just had treatment this morning,
Yeah, well, I'm gonna issue an arrest warrant for you. Bring you back down here. You cannot wait till the day you're supposed to be in court, enter into treatment, not be here. So I'm gonna have an arrest warrant issued for you for failure to appear. And
All right.
you'll be here on September. Where are you located? What town?
Hang on, I can't even think right now.
Is there someone else there?
Yes, 1 second.
So she's
Yes, I'm in Everett, Kentucky.
Everett, Kentucky. Okay. Well, there'll be, you stay there and we'll send somebody over to give you a ride back over here, okay?
All right,
Okay, thank you.
thank you.
Scotty Stearns. Did y'all get that? She was Everett, Kentucky. She's a warrant. Just issued a warrant for her. She's in Everett, Kentucky. Scotty Stearns.
He's back here with his attorney.
Okay, Steve Stearns. Let's do Scotty first. Scotty Stearns, 25 CR 0058. Are you Scotty Stearns?
Yes, sir.
Born in 1992. Last four digits, social security number 0390. You're here for a purpose of arraignment with your attorney. You have a right to remain silent. The grand jury, Clinton County is returning an indictment charging you with flagrant non-support. You understand what that is? Counselor, do you acknowledge the identity of your client, consider that, wait formal reading, arraignment, interplea, you got guilty, serving all three trial motions.
Yes, Judge.
And sign a reciprocal discovery order, sir, that requires the Commonwealth to give your attorney the information necessary to help prepare your defense. You need to be here on a negotiation date on September the 4th, and the next court date is on September the 11th, okay? Okay, Stevie
Thanks, Judge.
Stearns, Steve Stearns. Yeah, I mean, I want to arrest him.
Judge Ross was told she was sent to treatment by the SEC, your wife from the practice. That didn't hear treatment on the day that was supposed to, they said they didn't do the paperwork and issued her arrest.
Issue an arrest warrant. Just issue an arrest warrant and send it up to wherever county Everton, okay? You're gonna issue the warrant now, okay? Stevie Stearns, you're Stevie Stearns, good morning. We're here on 25 CR 0063. Were you born in 1987?
Yes, sir.
Last four digits, social security number 7231?
Yes, sir.
Are you represented by an attorney?
No, I'm not.
Okay.
Well, that happened.
I represent the district.
Okay, well, we'll continue that representation. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with possession of a destructive booby trap device. You understand what that charge is?
Yes, sir.
You acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, interplead not guilty.
Yes, Your Honor.
Reserving all pre-trial motion. What's Commonwealth, what's this case about? Talks about pulling a strip of nails across the road or something like that, or having it ready to do. What is this about?
Your Honor.
Allegedly.
Allegedly, Your Honor, there was like a piece of cardboard with some nails sticking in it and then grass. And I guess that the allegation or the thought was that he was going to use it.
So to be here on September the 4th for negotiation and September the 11th for the next court. I was gonna see if it was like a weapon of mass destruction or anything. I didn't know. Nathan Stockton.
That's right, that's it.
Are you Nathan Stockton?
I am.
Good morning. Good morning. This is 25 CR 0022 and 25 CR 0036. Mr. Stockton, were you born in 1991?
I was.
Last four digits, social security number 5920.
Yes, sir.
You moved to your left just a little bit.
Yes, Your Honor, we just entered into an agreed restitution order. We just need a new pretrial date just to see how he's paying on it.
Negotiation date on September the 4th. Next court appearance is on September the 11th, unless I receive a dismissal of the order. What you're saying?
Yeah.
Okay, thank you very much. Yeah. Angela Wallace. Angela Wallace. What was it about?
A dismissal. Her cousin entered the plea in December of 2024, and that was part of the agreement.
Okay, that's fine. Tyler Wright. Tyler Wright.
Oh, right, yeah.
Are you Tyler Wright?
Yes, Your Honor.
Well, the docket says you were born in 2022. I don't think that's correct.
That's 2002.
2000 what?
Well, it's in there as the, because he's showing up as a minor, and you pull up his case.
You're here for the purpose of arraignment in the Clinton County case. You have a right to remain silent, represented by Mr. Cross. Grand jury Clinton County is charged with a failure to signal, operating under the influence, possession of drug paraphernalia, possession of controlled substance, and possession of marijuana. You understand those charges? You acknowledge the identity of your client receiving indictment away from reading and arraignment or pleading not guilty.
Yes, Your Honor.
Okay, now we also were going to consider something in Cumberland Circuit Court Action 25 CR 0035. This is 0062 in Clinton County. What's the Commonwealth episode? You moved to your left just a little bit there.
Yes, Your Honor, in the Clinton County case, we have a pretrial diversion plea, I believe.
Correct.
And then in both, so, and then also the same for the Cumberland County. I got two separate pleas.
I think we had some concerns if these had to be done contemporaneous.
I understand. Did we decide to transfer the case over, the Cumberland County case over here and do them together?
Yeah.
It wasn't, they didn't transfer the file. Oh. So, yeah, no.
Just moved in here to have.
Nothing was said about transferring the case itself. It was just for the try to do a plea hearing and signature.
We had been around here.
Right, we tried to do it last.
I understand, I'm just going through to see if it would be preferable.
Yeah.
To send it over here, we combine the court costs that way and.
It's wonderful.
Just waiting.
Motion's been tendered that says you wish to enter a guilty plea today on both of these cases, is that correct?
Yes.
You know, it's a voice activated microphone, so you gotta speak to get the camera. Okay? Motion been tendered says you wish to enter a plea today, is that correct?
Yes.
On both the Cumberland and Clinton County cases, right?
Yes.
Are you currently under the influence of drugs or alcohol? No. Is this plea freely and voluntarily given?
Yes.
Are you the same person that we just identified in Cumberland Circuit Court case number 25 CR 0035 and Clinton Circuit Court case 25 CR 0062? Are you that same person?
Yes.
Is your judgment impaired today?
No.
Have you discussed the charges with your attorney?
Yes.
Are you satisfied with the advice of your counsel?
Yes.
Have you reviewed the evidence the Commonwealth has against you in both these cases?
Yes.
You believe you're fully informed? You understand that you do not have to enter a guilty plea. You have certain rights in the Kentucky United States Constitution before I can accept the pleas. I have to go down through the rights. Okay? At the end, I'll ask you to understand. You have a right not to testify against yourself. No one can make you say anything. The right to speak trial of a jury, right to be represented by counsel at your jury trial, the right to complain, cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose. Right to part of Commonwealth, proving unreasonable without you guilty charge against you. Understand that, but when you guilty plea, that you give up those rights. You understand that?
Yeah.
You may consider the Commonwealth's recommendation, but I may apply and arrange the same to provide the law. I don't have to accept your recommendation. In the event that I do not accept your recommendation, you decide to impose a harsher sentence, you can have a right to withdraw your plea. Now, I'm going to go over it. These are diversions in both counties. Is that right, counsel?
Yes, Your Honor.
Okay, I'm going to go over some qualifying things. Have you previously been diverted in the last 5 years?
No.
Have you had any felonies in the past 10 years?
No.
Are you currently on probation or parole?
No.
You understand that if you fully complete the these diversion programs, the case will be dismissed pre-trial diverted, you can have your record expunged. You understand that?
Yes.
You understand if you do not complete the diversion program, you'll be brought back before the court, and the court will schedule a sentencing hearing. You could be a convicted felon. You understand that? What is the Commonwealth's recommendation if you come forward? You step to your left just a little bit.
Yes, Your Honor. For Cumberland Circuit Court, indictment number 25 CR 35, Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 1 year. This sentence is to run consecutively with the Clinton Circuit Court case number 25 CR 62 for a total of 4 years, pretrial diverted for 5 years. Diversion is to be supervised. The defendant shall pay court costs at the discretion of the court. The defendant agrees to be assessed by the social service clinician and follow any recommendations. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole. For indictment number 25 CR 62 in Clinton Circuit Court, upon a plea of guilty to possession of controlled substance first degree, the defendant shall receive a sentence of 3 years. Upon a plea of guilty to operating a motor vehicle with alcohol concentration of or above 0.08 or while under the influence of alcohol or other substance, the defendant shall pay a fine of $200. This sentence is to run consecutively with the Cumberland Circuit Court case number 25 CR 35 for a total of 4 years, pretrial diverted for 5 years. Diversion is to be supervised. The defendant agrees to be assessed by the social services clinician and follow any recommendations thereof. The defendant shall forfeit $400 seized in the above style case. The defendant shall pay fines and court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky or the holding agency.
Is that your understanding of the Commonwealth's offer?
Yes.
Are you pleading guilty to these charges because you did commit the acts charged in the indictment?
Yes.
Knowing your constitutional rights, is it still your desire to allow the court to go forward with your sentencing?
Yes.
Yeah. The DUIs here are enhanceable. You understand that? You plead guilty to DUIs too. Just one DUI, is that right?
Yes, Your
I
Honor.
believe so,
One
yes.
DUI. So if you get other DUIs, that's enhanceable. It can be more serious penalties. You understand that?
Yes.
Okay, are you pleading guilty of your own free will? Because you are guilty for no other reason.
Yes.
Knowing your constitutional rights is still your desire to allow the court to fix your punishment, correct?
Yes.
Is that your signature on the motion, Alvin? You got
Yes.
one for Clinton and one for Cumberland there?
Yes, Your Honor.
Okay. Now I'm gonna waive the court cost in Cumberland. Okay, the DUI is here, right? There's a DUI in
Yes.
Cumberland.
DUI's here.
What's the court cost in DUI fees and things?
Thank you, Cook County, $975.
900, you need some time to pay that?
I'll pay today.
Okay. Okay, you go down and pay it today. You'll need to meet with, I guess probation and parole to get the information about it. Then is there a DUI? All the DUI documents are filled in? Okay, well, thank you very much. Okay, is LaRue County on there?
The rest of the line is right now, but we got Seth Roberts.
Seth Roberts, you wanna come up here, Seth Roberts? Okay, it says you make $280 an hour.
I wish.
I mean, it's a check all weekly.
Okay. I guess you did check by week. Okay, well, I'm gonna go ahead and $280 by week. I'm gonna go ahead and appoint you public advocate in reserve for later to see if I'm gonna require you to pay it. You're doing for the purpose of arraignment, the right to remain silent. The grand jury of Clinton County determined indictment charge you with flagrant and unsupported. You understand what that charge is?
Yes.
You acknowledge the identity of your client receiving indictment, way formal reading arraignment, your plea not guilty.
Yes, sir.
Sign a reciprocal discovery order. Requires the Commonwealth provide you with information. You'll be back here on September the 4th at 9 a.m. for negotiation. Next court date is on September the 11th. Okay? Thank you. Now we have Is Wayne County on there? Wayne County, are you on there? Let's do Wayne County. Just got a couple people. Commonwealth versus Nancy Raines. Are you Nancy Raines? Are you Nancy Raines? Somebody needs to turn the microphone over there, please. Little button that's shaped like a microphone. Shaped like a microphone, used to be shaped like.
Can you hear us, sir?
Yeah, now, yeah, that's good, thank you.
Okay, here they are. You ready?
Nancy Raines.
Yes.
22 CR 0067. Ms. Raines, were you born in 2001?
Yes.
Last four digits, social security is 0300.
Yeah.
You're on a pretrial diversion revocation. What's the Commonwealth have to say?
Yes, Your Honor. Ms. Raines, she was a drug court graduate in April of this year, and then just about a week later, she tested positive for meth. We passed it for 2 months to see if she could work on that, and she was still testing positive, so we're asking for her to be revoked.
We stipulate, Your Honor. I just asked that we consider sending her to long-term rehab.
Well, we'll have to handle this here first. Okay, so I'm going to revoke the pretrial diversion and have a pre-sentence investigation report done and have her over here on September the 11th for sentencing. We can determine that time what the next, we'll let her chill out over there just a little while and find out what we need to do. Ms. Raines, we're going to have to get you some help here some way. So they're going to come over and interview you, and then we'll let you be interviewed and see what we do next. Okay.
All right, thank you.
Yeah. Emily Savage. Are you Emily Savage?
Yeah.
Were you born in 2006?
Yeah.
Last four digits, social security number 7828.
Yes.
You're on a pretrial diversion revocation. What does the Commonwealth have to say about this case?
Your Honor, I believe the revocation, she's gonna potentially go to drug court.
Yeah, she agrees to that.
Okay, I'll sign a referral to drug court. They'll be over to interview you, and the drug court will be here in Clinton County if she's accepted.
I believe so.
Yes.
I didn't know whether she had charges over in Wayne County.
No, she lives in Clinton County.
Okay, well, they'll be over to interview, and I'll do a referral to drug court to see if you qualify, okay?
Okay.
Wayne County, thank you very much for your cooperation. Y'all are.
Thank you.
Somebody probably needs to contact, there's Russell County. Okay, let's start out in Russell County. Somebody will turn that microphone on there, please. Thank you very much. Commonwealth versus Winton Brown for arraignment.
You want to step up there?
Winton Brown, are you Winton Brown?
I'm Winton, WINTA, yes, sir.
Were you born in 1961?
61, yes, sir.
Last four
Yes.
digits, social security number 094.
0964, yes.
Okay, we are for arraignment 25 CR 0065. Your attorney's here, public advocate. Okay. You have a right to remain silent. Grand jury of Clinton County has returned an indictment charged with public intoxication, possession of drug paraphernalia, possession of controlled substance first degree, methamphetamine, possession of controlled substance first offense, another substance, possession of controlled substance not in the original container. Do you understand what the charges are?
Yes.
Good. Counselor, you acknowledge the identity of the client received indictment, away from the arraignment, including not guilty, voting out pre-trial motions.
Yes, Your Honor.
Okay, we schedule Ms. Brown to be over here on September the 4th. And for appreciation day, back on September 11th for that day. Sign a reciprocal discovery order so that your attorney can get information, help you prepare. What's your bond? So you just have a $15 surety bond. Approved, that somebody come in here to the clerk's office. It just shows that they're worth $15,000. They can sign and get you out. That's about as little bond as I can say, okay?
Okay.
Thank you
But
very
it can
much.
be,
Thank you.
it can be anyone,
Eric Claywell.
pardon me.
What did you say? I'm
I said
sorry.
it can be anyone as long as it's worth the 15,000, is that correct?
Clerk approves them to sign the bond. Anybody that lives in the you know, sign the bond, okay?
Okay, thank you.
Eric Claywell. I'm Eric Claywell. Good morning. This is NCR 0060. Mr. Claywell, you born in 1974. Last four digits, social security, 99. You have a motion here.
Yes, Your Honor. Motion for shock probation.
Tell me about it.
Claywell's been
You need to
incarcerated.
speak up.
Mr. Claywell's been incarcerated since February 14th, 2025. While he's been in there, he's completed MRT, trauma focused rehab program. I know he wants to do additional programs. But this case stems from conduct in 2019. The case just took a long time to get resolved. He's in a better place. He was in a better place actually when we went to trial on this one. While he's been in there, he was the primary caretaker for his mother. She's now in a nursing home. He wants to get out. He says he's fine to continue with some type of outpatient treatment to make sure he stays on a good path. He wants to get out and be able to take care of his mom.
Your Honor, it's my understanding that Mr. Claywell, he met with the parole board in June of 2025, and he was given a serve out date, which would take place in February of 2026. And I believe the underlying charge was a DUI for him. And so, and depending on what type of classes that he's taken there, his serve out date maybe
You need to speak up.
I said on to what type of resources he has at that prison that he's at right now, his serve out date may be moved up. So I believe he's been able to chip some of that away.
I'm hesitant to take issue with the parole board in this situation. This was a trial by jury. Sometimes we wait to see what the parole board does. And if they, because it's better to get parole than it is probate. But I'm not going to interfere. This is a jury trial. It's, you know, I remember it well. So, the only over here, two different individuals in the county been killed by driving people driving. Somebody's got 4 DUIs, a very serious situation. I appreciate Mr. Clayble's improvement, but I'm shocked with it. Okay, thank you very much. Virginia Connor.
Yes, sir.
Commonwealth versus Virginia Connor, 20-005. You're here for sentencing.
Yes.
You born in 1983.
Yes.
Last four digits, social security, 3717.
Yes, sir.
Somebody's got a radio or something that's hearing there. I don't, seems to be interfering in the broadcast. Have you had an opportunity to put the pre-sentence investigation report done by probation parole?
Yes, sir.
You need to back up or lower the camera. We can't see you. That's good. Is it substantially correct?
Yes, sir.
Counselor, is there any reason that this could not be done?
No, Your Honor, I'd just like to make an argument that the full remainder of her
You
sentence.
want to identify yourself?
Yes, I'm sorry, Judge. I'm Shelby Crawford. I represent Ms. Connor.
Okay, you have something to say, go ahead.
Thank you, Judge. Ms. Connor was sentenced to 6 months to serve and the remainder is 10 years probated. We would just like the court to consider probating the remainder of those 6 months. I believe she's been in over 3 months now. She seems to be doing great. She's got 2 pretty young kids at home. She's also had a great job before being incarcerated. I think she could go back to that. She was a nurse assistant, and traveled, made pretty good money. So we would just ask the court to consider that, or in the alternative, consider allowing the remainder of these 6 months, which is just a little under 3 months, to be served on home incarceration.
What was the comment?
We oppose that, Your Honor. This,
Will come up,
yeah.
you move to the left.
Your Honor, whenever we worked out this plea, it was with the victim in the case, and the victim agreed to this type of plea, so we're just opposing any type of probation other than that's been agreed upon.
On a plea of guilty to theft by law, disposition over but less than $1 million, the defendant shall sentence of 10 years, 180 days with probated for 5 years. The defendant shall pay restitution going severally with Christopher Guffy amount of $6,200, $250 within 30 days of being released from incarceration. Restitution is subject to 5% probation should be supervised. She should receive credit for time served. What was the court cost in this case?
$155.
$155. Pay an additional $30 a month starting 30 days after you're released on the court cost. Okay, thank you very much.
That's all I have. That could be excused.
Yeah, absolutely.
Thank you.
Brandon Hall. Are you Brandon Hall?
Yes, sir.
Morning.
Good morning.
This is 25 CR 0039. Mr. Hall was born in 1982.
Yes, sir.
Last 4 digits of your social security number, 3773.
Yes, sir.
I understand you wish to enter. Is that correct?
Yes, sir.
It's a felony plea. Is what we got
Yes,
here.
yes, Your Honor.
Okay. Motion has been taken. Said you wish to enter the plea. Are you currently under the influence of drugs?
No, sir.
This is plea free and voluntarily given.
Yes, sir.
You're the same person that we just identified in CR 0039.
Yes, sir.
Judgment impaired today in any way.
No, sir.
Have you discussed the charge with your attorney? Are you satisfied with his advice?
Yeah.
Review the evidence that's against you, believe you're fully.
Yes, sir.
You understand that you do not have to, you have certain rights of protecting the United States Constitution before I can accept the plea. I need to know.
Yes, sir.
Okay, you understand?
Yes, sir.
You have a right not to testify against yourself. No one can say the right to speed trial by jury, be represented by counsel at your jury trial. The right to confront and all witness called testify against you, right to produce evidence, right to call with favor, right to appeal this matter to higher court if you lose, and right to call the Commonwealth to prove on a reasonable doubt that you're guilty of charge. You understand that by entering a guilty plea, you
Yes, sir. Yes.
Yeah, I may consider the Commonwealth's recommendation, but I mean, by the law, I don't have to accept any recommendation. Prior to accepting your recommendation, all what precincts investigation report will be done. Well, in the event that I do not accept the recommendation, decide to impose on 100%, you have the right to withdraw your plea of guilty and proceed to trial. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to trafficking in a controlled substance, first degree, second offense, the defendant shall receive a sentence of 12 years to serve. The Commonwealth opposes probation and shock probation. The defendant shall receive credit for time served. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that your understanding, Commonwealth's recommendation?
Yes, sir.
You're pleading guilty because you didn't commit the acts charged in the indictment as amended?
Yes, sir.
You're guilty of your own free. Knowing your constitutional rights have explained is still your desire to allow the court to punishment within the range by law. Is that correct?
Yes, sir.
You send it back to hearing enhance and range persistent felony federal law. Do you understand that?
Yes, sir.
Accept the agreement. Is that your or pre-sentence investigation? Schedule sentencing for September the 11th, okay?
Thank you.
Thanks, sir.
On set for trial for Monday, so we just need it.
Okay, we will
canceled.
take it all Monday, okay? Okay. Ashley McCusker.
Yes.
Is Brandon Hall a state prisoner now? Is that correct?
He may have served out by now, Judge. He's really close.
He's been incarcerated either way, correct? He hadn't been out since his last PSI.
Yes, he has been. Yes, he has served out on his
Okay.
current case.
Okay. Ashley, are you Ashley?
Yes.
You born in 1987?
Yes.
Social Security number 5.
Yes.
On a motion for shock probation. What do you have to say?
Ms. McCusker, while incarcerated, has gotten her GED.
Speak up, sir.
Sorry, Ms. McCusker, while she's been incarcerated, has gotten her GED. She's enrolled in a portals program and an anger management class currently. She's not asking to be released without any accountability. She wants to go to long-term rehabilitation upon release, and she wants to get back and be there for her 4 children. 2 of them have special needs, and I know they rely on her quite a bit.
Your Honor, I believe that she will be meeting the pro board in November of 2025. She's been on probation before. She ended up getting a new felony. She went to drug court. She was terminated for drug use. So we ask that she just remain incarcerated.
Well, I'd be better off parole board. Being on parole is better than being on probation as far as the level of supervision. So I'm going to deny your motion. Thank you very much. Mary Russell. Commonwealth versus Mary Russell, 5 CR 0067. Are you Mary Russell?
Yes, sir.
You born in 1975?
Yes, sir.
4-digit social security number 6106. You here today?
Yes, sir.
You here today for the purpose of arraignment. You previously represented the Office of Public Advocacy. Public Defender's Office. Did the Public Defender's Office represent you before?
No, sir.
I've reviewed your form here. It appears to me that you are eligible to have a public advocate appointed, so I'm going to appoint them to represent you at this time. I'm going to. Okay. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging murder. You understand what that charge is?
Yes, sir.
Counselor, do you acknowledge that your client waived formal reading or an interview, reserving all pretrial motions?
Yes, Your Honor.
Sign a reciprocal discovery order, ma'am, that requires the client to provide you with the information to prepare for your defense. Is there any reason to have a negotiation day for a charge like this soon, or you want?
I think you need one soon, Judge.
Okay, well, what I'm gonna do is I'm gonna schedule the next appearance since she just got counsel today. We'll schedule her next appearance to be on October the 9th. And if there is a reason to negotiate murder case, I'll just let y'all decide that between.
All right, there's a lot of data on DocuShare.
Okay, thank you very much. Now, Russell County, do you have anybody else that appears to be wanting to hear us today?
Your Honor, that's all we had on the list you all sent us, so.
Thank you very much for your cooperation. I'll have a blessed day.
All right, you all too, Your Honor.
Okay, let's go to Clinton County's on there.
Yeah, I mean, the other check office. They were really not, last thing we did, and we got a call on the future, I seen an order of a few weeks ago.
And I have tried too for Pulaski. I'll keep trying for Pulaski.
I've got a client in Velasquez, tried as well, they're on nursing transport, so entered, and it says it's being sued. I got a copy of it, I thought it was actually gonna be transport, I didn't see sued on it, but apparently they're not responding to that, I had my secretary.
Do you know anybody over there at the Pulaski County Jail that would do you a small favor and get on?
I'll see what I can do, I'll call my secretary.
Okay. Well, let's go off the record just for a second. Maybe we can call it, they're not answering at the jail. Could y'all call the Pulaski County Sheriff's Department and tell them we need to talk to the jail if then maybe they can get the response. Let's go off the record.
Let me try one more time, Judge. Hey, this is.
I got a text from my secretary, says they are working on it.
And I am out of Clinton County, but we need them to get on the court by Zoom for Clinton County Circuit Court.
make sure. We're attempting to get a hold of the Pulaski County Jail in the case of Mr. Jarvis. We've been in Eddie K. Jarvis. We've been informed that they've got some kind of mechanical problem with one of their jail cells up there. We're going to try to rectify that, but I've called counsel for the Commonwealth and for Mr. Jarvis. I've received a communication from some individual that trying to make motions and file motions in this case on behalf of Mr. Jarvis. His name is James Barry Murphy. And I have requested that the Commonwealth refer Mr. Murphy to the Bar Association for attempt to practice law. He has absolutely no authority to make motions or this court in front of this court for anyone. Individual can come themselves and make a motion, but Mr. Jarvis has able counsel here. And Mr. Murphy doesn't need to be meddling in this case whatsoever. So we'll make a referral to that and see if there are any criminal activity involved in this.
Your Honor, just for the record, that individual, I believe it was that individual, did make a phone call to my office. I spoke with him. He offered paralegal services. I told him I wasn't interested in paralegal services. Declined further phone calls from him and so forth. And let him speak to get this. So.
Okay, that's fine. Well, we'll see what the Bar Association has to say if there's any criminal activity for him attempting to practice law here. It sounds like to me we have a jailhouse lawyer involved here. Okay, there, Mr. Jarvis. That's the
predatory. I think it's predatory.
Yeah. Okay. Y'all will turn that microphone on. I appreciate that. Thank you so much for your cooperation. This is okay. We lost Pulaski County. We had him for a second. Well, as soon as we get Pulaski back on again, we'll start to try to do something. Let's go to the Clinton County Jail, and if y'all will watch when Pulaski comes back up, we'll try to get them to meet. Clinton County Jail. Colton Abston, Clinton County Jail. Okay, I got Pulaski County back on. Y'all will turn your microphone on there, Pulaski County. Should be a little red microphone dot.
Yes, okay, we got it, thank you.
Got it now, thank you so much. This is Commonwealth Kentucky versus Eddie K. Jarvis. You got turned off again, hit it again. Clinton County, we'll get to you in just a minute. Okay,
Can you hear?
Pulaski,
Can you hear me?
I can hear you now, thank you. This is Commonwealth of Kentucky versus Eddie K. Jarvis, Clinton Circuit Court 25 CR 0064 for the purpose of arraignment. Mr. Jarvis, were you born in 1947?
Yes, sir.
Last four digits of your social security number 7422.
7422, sir. My ears are off the board, sir.
Okay. You have a right to remain silent. Mr. Bertram, your attorney, is here today. The grand jury of Clinton County has returned an indictment charging you with wanton endangerment in the first degree, 2 counts, and resisting arrest. You know what those charges are. I'm not asking if you did or not, but you understand the charges, right?
I don't understand why I'm being charged with them.
No. You understand what the charges are?
I think I do.
Okay, thank you very much. Counselor, you acknowledge the identity of your client received the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor, I do.
Okay, I'm signing a reciprocal discovery order that will allow, Mr. Jarvis, for your attorney to receive information. Now, about your case, we'll set a negotiation day in this thing for September the 4th. And the next court date is September the 11th. Okay.
Do I understand you right, sir, that you're saying?
Wait a second. Now, there's a bond reduction motion.
Yeah, there's also,
You need to speak up so we can hear you.
the Commonwealth's motion is to revoke the bond. We've made a motion to reinstate the bond, filed a written motion specifying the details of that. Mr. Jarvis has a number of serious medical conditions. The court's repeatedly entered orders allowing him to go to treatment. He has another appointment actually today. We have a transport order for that for a hearing.
Okay, what does the Commonwealth have to say? If y'all will come up. You sit to the left and I'll get back to the right.
Yeah, our motion to revoke bond is based on him contacting his doctor.
You need to speak up.
The basis of our motion is because he had contacted his doctor and had left a very threatening voicemail. We actually inserted the transcription of the voicemail in our motion as to what he said on it to the doctor. So that was the basis of our motion.
That's the entirety of it, Your Honor. I've listened to the audio tape. I've looked at the transcript. I've discussed it with my client. He did make the phone call to his doctor repeatedly. He woke up with his leg swollen 3 times.
It sounds like to me that there needs to be a bond reduction or a reinstatement hearing on this thing.
Yes.
So, I mean, your client, would put a different light on the conversation and that sort of thing. When can y'all schedule that? Where are we at next Thursday? We're in Monroe County. That's farther than you want to go, probably in Monroe County.
I can go to Monroe County.
Let's just schedule, and we can do it. The doctor can appear by Zoom.
What time would we be doing that? I've got doctor dentist appointment 2:30.
Okay, well, let's schedule it at 9, and we'll take you first.
Okay.
If y'all will we'll send a Zoom link to any witness you have for convenience, and then we'll also send a Zoom link to the Pulaski County Jail.
Okay.
Okay, now, is someone from the jail present there, somebody representing? I have received an attempt from someone by the name of James Barry Murphy that appears to be one of your inmates there.
Yes.
And he's attempting to practice law here, trying to get me to recuse myself.
I took no part in that, sir.
Okay, well, I'm informing the jail of that. I'm not saying you did, sir. I'm just informing the jail that y'all need to tell Mr. Murphy that I'm reporting him to the Bar Association. We're gonna see he's attempting to practice law. He has no authority to file anything in there. If y'all will impart that to him, he needs to butt out. This gentleman has a very accomplished attorney representing him, and we don't need Mr. Murphy's comments or participation. Tell him that I don't want to hear anything else from him again, okay?
I will let him know.
Okay. Thank you.
I'm not asking him to represent me.
I didn't say you did, so that's the reason I didn't address it to you. I'll address it to him. And your attorney's aware of it too, and your attorney said on the record that he's representing you, and he didn't ask Mr. Murphy to do anything. Thank y'all very much, Pulaski County, for your cooperation.
All right. So you gonna send a Zoom link later?
I will for next week. I'll send you the Zoom link for next week, okay? It's next Thursday.
Sir, do I have the right to speak for a second?
Well, no, because your attorney's here. He'll speak for you, but we'll have a bond. We'll try to see about reinstating your bond. We'll have a hearing on that next Thursday, okay?
Yeah, an order for his.
Thank you very much.
An order for his appointment this afternoon, if you could sign.
Yeah, I'm gonna sign a transport order for your medical appointment, okay?
Today.
Yes. Somebody, y'all have to go up and get him, do you? Okay, I'll send a transport order for the medical appointment today. Thank y'all very much.
Thanks, Judge.
I just need to get a copy of it. Thank you, Ron.
Yeah. Now, did we ever get LaRue County on?
We don't have to look at either, but on Justin Day, it's just a motion for the Longwell to secure it out of state witness.
Do y'all have any objection on the motion to secure an out-of-state witness on Commonwealth versus Justin Day?
No, Your Honor.
Y'all get an order in on that. Is that right, Ms. Gordon Anderson? Yes. Okay, now, is there anyone else anywhere besides Rodney Manis at LaRue County? Yeah. Can we call the Laurel County Sheriff?
LaRue, let me
LaRue
see,
County Sheriff.
let me work on LaRue County.
Okay. Y'all, does Commonwealth have anything else? Is that it? Show over?
Just Clinton jail. That's.
Okay, if there's nothing else we need on Zoom, let's go to the Clinton County Jail. You can turn your microphone on.
Yes, sir, we're here.
Commonwealth versus John Beatty. Are you John Beatty?
No, sir. You want John Beatty?
Well, I'll say, what's your name?
Come here. Step back. There, you want to go.
Wait a second.
Sir, John Beatty, Your Honor.
Okay, and then I'll do Colton next, okay? Commonwealth versus John Beatty for sentencing. Are you John Beatty?
Yes.
Were you born in 2000?
Yes.
Last four digits, social security number 8125.
Yes.
Have you had an opportunity to look at the pre-sentence investigation report number, probation, parole?
Yes.
Substantially correct. Counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On a plea of guilty to trafficking and controlled substance first degree, first offense, the defendant shall receive a sentence of 10 years, serve 180 days with a balance probated for 5 years. He shall receive credit for time served, and shall obtain gainful employment. And this is supervised, correct?
Yes.
Supervised. So when probation parole will come up, how many days does he have in there, you know?
79.
You what?
79.
So they'll be up to, probation parole will be up to interview you, Mr. Beatty, in preparation of your release after you serve your agreed upon time, okay?
All right.
Thank you very much. Now let's go back to Colton. Colton Abston.
I am now.
Colton Abston.
Hey, Colton Abston.
Are you Colton Abston?
Yes, sir.
What's your year of birth?
July 1st, 1998.
Last four digits of your social security number, 4431.
Yes, sir.
Okay, you're here on 25 CR 0066 for the purpose of arraignment. The right to remain silent. Your attorney is here in court, okay? Grand jury of Clinton County is returning an indictment charging you with 2 counts of assault 3rd degree. You understand what the charges are? I'm not asking if you did or not, just understand what the charges are. Is that correct?
Yes, sir.
You acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay. What is the bond sit on this thing?
It is $2,000.
$10,000 cash bond, September 4th for negotiations September the 11th for the pretrial, and I'm signing a reciprocal discovery order, Mr. Abston, so they can work on your case with you and help prepare your defense, okay? Thank you very much. I'm signing an order allowing the public defender to represent you. I'm signing an order allowing the public defender to represent you, okay? Thank you. Okay, let's go now to Christopher Guffy. Cromwell versus, are you Christopher Guffy?
Yes, sir.
Yeah, we're here on 24 CR 0072. Mr. Guffy, were you born in 1976?
Yes, sir.
Last four digits, social security number 5843.
Yes, sir.
You're here today on a pretrial diversion revocation. You're represented by Office of Public Advocacy. Was Mr. Leverage a special prosecutor in this case?
Sure, Your Honor.
No, this one, this is on the.
It's listed on the document, that's not.
Stephen Poindexter is listed as count.
However, I haven't had any contact with him since since this motion was filed.
Is Mr. Leverage,
Oh, it's Leverage.
was he the prosecutor in the case?
Oh, my God. Is it 24/7? It's ours.
What's the story on this?
Mr. Guffey, he had a recent felony charge in Wayne County for trafficking. I believe that he has just
You need
recently.
to speak up.
I believe he's just recently entered a misdemeanor plea on that case in Wayne County, and he's just had some positive meth. He just had some positive meth, drug.
Okay, well,
screens.
let's schedule this for a revocation, pretrial diversion revocation. Because we don't have, have you prepared for this?
I've spoken with him briefly. I know he wants to go to drug court if possible.
When is Leverage special prosecutor or is that a mistake? No?
We just don't, given his trafficking charge.
Does he want to stipulate since he had traffic, sorry? I will stipulate and I will revoke the pretrial diversion and schedule a sentencing for September the 11th. And at that time, we'll consider treatment or growth or probation, whatever we need to do. Okay?
Okay, thank you.
They'll be down to speak to you, Mr. Guthrie. Thank you. John Diamond. John Diamond. Combo versus John Diamond, 21 CR 0054. Are you John Diamond? Are you John Diamond?
Yes, sir.
Okay, good morning. Were you born in 1991?
Yes.
Last four digits, social security number 7313.
Yes, sir.
21 CR 0054 for a probation revocation. What's the comment have said?
Your Honor, I need to raise an issue.
Okay, what is the issue?
I'm gonna have to get out of this
You need
case.
to speak up a little bit.
I said, I'm going to have to withdraw because when I got this on John Glenn, there's an EPO involved with an individual I'm doing current work for. And I advised Mr. Stockton and Mr. Rutherford, I felt like I had a conflict. So I think the PD needs to be appointed and probably the thing passed until we can deal with it. But I'm just not.
Mr. Cross is wanting to withdraw from your case because he said that there's a domestic violence situation that involves someone does it involve this Mr. Diamond himself?
Yes, that's one of the grounds for the revocation.
Yeah.
So I don't think I can do anything.
Mr. Diamond, can you afford another attorney or I need to appoint a public advocate?
I believe I've already got one, sir. The guy sitting behind David there, I think I've already spoke with him.
He spoke to him because I told him it looked like we were gonna have.
I'll allow you to
conflict, but I don't
withdraw,
think
Mr.
he's been
Cross.
appointed, so.
Yeah, I spoke with him because he didn't feel like that.
You're
David Cross
excused, Mr. Cross, you're
was gonna-
excused. Mr. Cross is excused.
Thank you.
She was supposed to
Cross
have
was gonna
dropped that.
represent
Wait
him.
just a second. Go ahead, speak up.
But he wasn't sure if Mr. Cross was gonna represent him. He didn't think he
Okay, now
was.
we're sure now. What do you got on this?
So I would like to have, if we could schedule one more day, just so I could talk to him.
Okay, September the 11th, we'll do a negotiation on September 4th and then on September the 11th. Both of those are, he's being held without bond now because it's on a probation revocation. So your new attorney will be down to talk to you, okay?
I'll come see you.
Okay, thank you very much. Mitchell,
Is that all, sir?
Mitchell Finley,
Okay.
thank you.
Thank you.
Commonwealth versus Mitchell Finley. Mr. Finley, were you born in 1966?
Yes.
Last four digits of social security number 0720.
Yes.
Your attorney, Mr. Cross, is here. It's a motion to determine competency.
Your Honor, we're going to stipulate based on what's within the record and Mr. Stockton and I.
Stipulate to his competency.
Yes. And Mr. Stockton and I basically have to tweak it and work it out.
Negotiation day on the 4th and the 11th is the next court day. So, Mr. Finley, your attorneys have stipulated that you are competent and they're going to negotiate with the Commonwealth on the 4th of next month, and you'll be back here on the 11th. We'll need to have you present or have a Zoom for both days. We'll take care of getting you here, okay?
Thank you, Your Honor.
Thank you. Thank you very much. Tyler Holland. Tyler Holland. Is it Holland or Holland?
Holland.
Commonwealth versus Tyler Holland, 23 CR 0040. Mr. Holland, were you born in 1996?
Yes, sir.
Last four digits, social security number 0998.
Yes, sir.
Okay, we're here on a probation revocation. What's the Commonwealth have?
In lieu of our motion for revocation, we would ask, I think we've agreed that he would go into drug court.
I'll sign a referral to drug court. They'll interview to see if you can be voted in. You'll remain incarcerated until then. And we won't, Commonwealth is not seeking to revoke you now, but to give you another chance, okay?
Thank you, sir.
Dennis Kempton.
Hey, Dennis.
Commonwealth versus Dennis Kempton. Are you Dennis Kempton?
Yes.
This is 23 CR 0060. Mr. Kempton, were you born in 1974?
Yes.
Last four digits, social security number 8161. This is a probation revocation.
Yes.
What Commonwealth have to say?
Yes, the basis of our motion is that he's absconded, he's failed to complete inpatient treatment. He's had a positive test for Suboxone and he had a new misdemeanor charge at the time of his arrest. And he's received a new felony charge while being in the Clinton County Jail for intimidating a participant in the legal process. So.
Y'all stipulate.
We stipulate.
This, Mr. Kempton, your attorney on your behalf has stipulated you will revoke your probation. And how much time does he have? You get credit for time served up to this point. Okay, thank you very much. Zachary Markham. Zachary Markham, 25 CR 0011. Pretrial diversion revocation. And then we have a new indictment in 25 CR 0030. Your attorney's here. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging fleeing or evading police in the first degree, fleeing or evading police on the first degree on foot, wanton endangerment in the first degree, tampering with physical evidence, assault third degree, and resisting arrest. Do you understand what those charges are?
Yes, sir.
Okay. Counselor, you acknowledge the identity of your client, received the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, I'm signing a reciprocal discovery order. Mr. Markham, with the attorneys getting information to help prepare your defense. We'll have a negotiation day on the 4th of next month at 9 a.m. here, and at the 11th, on the 11th, your next court date. If you want to transfer, you'll need your transportation.
I will.
Okay, your attorney wants to talk to you. Kevin Miller. Kevin Miller is next.
Kevin Miller next. Kevin Miller, Scotty. Kevin Miller.
Holding abatement, abatement's a pre-trial diversion. Kevin, are you Kevin Miller?
Yes, sir, I am.
25 CR 0052, you're here for arraignment. You have a right to remain silent. Were you born in 1966?
Yes, sir.
4 digits, social security number 8677. Yeah, I have reviewed your application to have an attorney appointed. I think you qualify for public advocacy. So I'm going to sign the order. You have a right to remain silent. The grand jury of Clinton County returning indictment charging you with possession of controlled substance of first degree methamphetamine and possession of drug paraphernalia. You understand what the charges are, don't you?
Yes, sir.
Okay, I'm going to sign a reciprocal discovery order. The Commonwealth will provide your attorney with information to help prepare your defense. What's this gentleman's bond?
It's 25,000.
I look at it.
We have like we're going to it was maybe the whole state of the students into this.
He has an out-of-state address.
He does. I know he wants me to ask if the court would consider amending that to an ROR bond.
Where does he live?
He lives in, I think it's Pickett County, Tennessee. Is that right, Mr. Miller?
Yeah, Pickett County, Birchtown. Been there for over 5 years. I ain't going nowhere.
Yeah, you have somebody in Clinton County that can sign a bond for you? You know anybody in Clinton County?
No, sir. No, sir, I don't. I don't.
You have a job? You're disabled, aren't you?
Yeah, but I'm really needed at home, sir. My brother has had a hip operation and he's in a wheelchair and I take care of him.
So about just a possession, it's a possession charge.
You don't want to think about it.
Your Honor, I'm not going nowhere.
Plus he was out of state and he wasn't in the CIC. By the time at all, and he's not going to probation.
He signed a waiver of extradition. He wasn't in NCIC very long.
We'll give him a chance.
Do what?
We'll give him a chance.
Okay. I want him to sign one of these waiver of extradition forms that we have up here that he'll come back. If you'll take that down to jail, he'll sign that.
I will, Your Honor.
I'm gonna let you sign your own bond for $15,000. Okay?
Okay, yes, sir.
You don't come back.
I'll come back to court.
Yeah, okay. Your next court, you need to be up here for a negotiation day here at the courthouse in Clinton County on the 4th of next month at 9 a.m. And then you'll need to be back here for your next court date on the 11th of next month, 4th and the 11th. Now, does your attorney have a number to get a hold of you at anywhere or anything?
Yes.
Okay, you have family members here, and the family members will give the contact information where they can contact you. Make sure you discuss this matter with your attorney when you're here on the 4th at 9 a.m. and on the 11th at 9 a.m. Okay?
Okay, I will.
You know, send a couple of papers down there to the jail for you to sign, okay?
Okay.
Thank you.
Thank you, sir.
Nicholas Purdue.
I need them good now, right? Good now. So I said, right?
Commonwealth versus Nicholas Purdue. You are Nicholas Purdue?
Yes.
Okay, good morning. Were you born in 1992?
Yes.
The last four digits, social security number 7832.
Yes. No, it's 7862.
Okay, we'll change that, 7862. You're here for the purpose of arraignment, you have a right to remain silent. Your attorney is here. I just signed a public advocacy appointment for you. The grand jury of Clinton County has returned an indictment charging you with careless driving, failure to signal, disregarding a stop sign, disorderly conduct, menacing, driving on a suspended license, resisting arrest, and failure to have a insurance. Now, there is a obvious typographical error in that last charge, says Monroe County in the body, so I'm gonna change that to Clinton County. Without objection, you have any objection?
No objection, Your Honor.
And then the final one is possession of controlled substance and first degree methamphetamine. You know what those charges are that I just read to you? I'm not asking if you did it or not. You understand the charges?
Yes.
Counselor, do you acknowledge the identity of your client receiving indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Mr. Purdue, I'm signing a order of reciprocal discovery order requires the Commonwealth to give you the information necessary to prepare for your defense. So we have there. Scheduling a negotiation date on the 4th of next month, and on the 11th is the next court appearance, both of them. Now, he has a resisting arrest charge. Y'all want a bond hearing before you do any bond reduction? $25,000 surety. That means anybody can come into the clerk's office here and prove that they're worth $25,000 to the clerk, and they can sign you out. It won't cost them anything, unless you don't come back. Okay?
You actually should use it. For next month.
But I'll let it be assured. Y'all have any objection to $25,000 clerk approved surety?
Oh, no.
Okay, we put a curfew on there too, so you need to go down and explain to him
I
why
will.
surety. You don't need to be messing around with any law enforcement officers or anything while you're out. You understand what I'm saying?
Yes.
I mean, it's good, you know, it's a good way to get hurt. But your attorney will be down to see you about the bond, okay? Thank you. Larry Thompson, Senator Larry Thompson.
Larry?
Larry Thompson. Are you Larry Thompson?
Yes, sir.
This is 25 CR 0026. Mr. Thompson, were you born in 1979?
Yes, sir.
Last four digits, social security number 2745.
Yes, sir.
You're here for sentencing. If you had an opportunity to look at the pre-sentence investigation report done by probation and parole.
Yes, sir.
Substantially correct. Is it correct?
Yes.
Yes, sir.
Is there any reason this gentleman should not be sentenced?
No, Your Honor.
On a plea of guilty to burglary second degree, shall receive a sentence of 10 years. On a plea of guilty to theft of lawful taking over 1,000. At persistent felony, he shall receive 10 years. The two sentences run concurrently for a total of 10 years. Probated for 5 years, probation is to be supervised. Defendant agrees that probation will continue to all restitution is paid in full. The defendant shall receive period for time for serving. He will pay restitution to Terry Pierce in the amount of $20,000 payable at $200 a month. First payment will be due on September 2025. Due on the 15th of each month until paid in full. Defendant agrees that all evidence should be destroyed. What are the court costs in this case? 165, 155, and you'll pay additional $30 a month court costs starting 30 days from getting out of jail. Do you understand that?
Yes, sir.
Okay, probation and parole.
I'll be down to the jail to see him soon as court is over, so whenever
We'll
you.
come right down there and get you to fill out some papers as soon as court's over, okay?
Okay.
Okay, thank you very much. Richard Thompson. Commonwealth versus Richard Thompson, 25 CR 0029. Are you Richard Thompson?
Yes, sir.
You born in 1976.
Yes, sir.
Last four digits, social security number 1479.
Yes, sir.
Here for sentencing today. You looked at the pre-sentence investigation report down the probation role. Has he looked at that?
He did, Your Honor.
Is it substantially correct?
The only changes, Your Honor, the legal mailing address shows an address in Moorhead, Kentucky, which is incorrect. It would be his last community address. And then also it has his father as, the father is deceased as of December 3rd, 1989. The date there is wrong. So, but that's all, Your Honor.
Okay, this was a jury trial. There was a found guilty on traffic and controlled substance. 2 or more grams, got a 7-year sentence.
Yes, Your Honor.
Also, was found guilty of a DUI.
Yes, sir.
Also, no tail lights.
Yes, sir.
So, I guess you should be informed that the DUI is enhanceable. You found guilty by a jury. If you get another DUI, it's enhanceable. And, the jury verdict on the felony is enhanceable. What is the court cost of this?
Plus fines.
Plus fines,
Yeah, $820.
Okay, $820 your court costs and fines. I'm gonna hold that in abeyance. You'll start paying that 30 days after your release from incarceration.
Yes,
You
sir.
pay it at $100 a month. Okay, thank you very much.
Thank you, Your Honor.
Robert Wright. Robert Wright. Robert Wright is down in jail down there.
Yes,
Clinton
Yes.
County.
Yes, sir, he wasn't on our list. We'll get him right now.
What else do we have? Okay, LaRue County, we're gonna be with you next. I think one case. Well, let's go to LaRue County now. Let's go ahead. Thank y'all for getting in contact with us. This is Clinton Circuit Court, 22 CR 007, Commonwealth of Kentucky versus Rodney Manis. Mitch, are you Rodney Manis?
Yes, sir.
Okay, were you born in 1970?
That's great.
Last four digits of social security number 3824.
Yes, sir.
Okay, what's the Commonwealth have to say? It's a motion or shock probation?
Rodney Manis.
You file a motion?
Yes, I filed a motion.
Tell me something.
Well, he's completed some programs while he's in there. He's been in for a little longer than 6 months now. He's ready to get out and pay his restitutions. I think a big part of his problem was a substance abuse issue, which he thinks.
What's the underlying, what was the sentence for?
I know he owes about $18,000 in restitution. Looked like theft by unlawful taking parts from a vehicle.
You need to speak up.
It's theft by unlawful taking parts from vehicle over $10,000. I think he owes about $18,000 in restitution and he just wouldn't pay when he was out. So that was our biggest issue with him. Was that
We have LaRue County on there now.
There he is.
Yeah, are you Rodney Manis?
Yes, sir.
Okay, the other fellow identified himself as Rodney Manis, so.
he also had to go in NCIC too. So
What do you have to say about that? Was he a Tennessee resident or what?
I believe he is, or he was a Tennessee resident. Is that right, Mr. Manis?
Come again with that? What do you say?
Are you Tennessee?
Yes, sir. I'm a Tennessee resident. I'm sorry.
How much restitution does he owe?
$18,000. He meets the parole board April 2026.
Mr. Manis, I'm going to ask you a question, do you have any probability of anybody coming up with this restitution money?
All of it, not all at one time.
Well, does Commonwealth have a suggestion of how much would be amenable to get restitution for the victim? It's 22,000 owed or something like that.
$5,000 at minimum, but it's just the other problem, I mean, just trying to find him afterwards. I know that, Mr. Payne here said you need an address for him. He doesn't think Tennessee will even take him back, so.
He's already been in ICOTS once, and usually when you send one the first time, if they get closed out, they usually don't take them the second time. From my experience.
Well, that'd probably be true, but if he makes a parole board, there'd never be restitution. Right?
Well, if he gets released on parole, he'll stay on supervision till his parole is paid.
And the judgment always at restitution.
Yes, he'll stay on parole as long as he don't reach MRS. If he just reach regular parole, he'll stay on supervision till his restitution is paid. That's a condition.
When he's gonna try to parole boards.
April between next year.
Yes.
Okay, I'm gonna give you an opportunity. If you come up with $10,000. You come up with $10,000 to pay toward this restitution. I'll consider your parole thing. You know, you've had some rabbit blood in you, man. It's been hard to find you. And, your probation will last until the restitution is paid in full anyway. And that'll give you an opportunity to save you several months. So if you'll contact your lawyer and make $10,000 payment and then regular payments on the balance of that. Now, the problem that you're gonna have is Tennessee very well might not take you back on supervision down there. So you have to work through that. But the first step that you get is trying to get $10,000 payment toward restitution, okay? Your attorney will need to talk to you.
Yeah, I'll call you today.
Thank you very much. Okay, what else do we have there? That's all we have in LaRue County. Thank y'all, LaRue County, for your help.
Yes, Your Honor.
Somebody on Zoom.
Clinton County, turn your camera back on.
Yes, sir.
Robert Wright, you got Robert in there yet?
Yes, sir. He's right here.
Commonwealth versus Robert Wright, 20 CR 00070. Mr., are you Robert Wright?
Yes, sir. Yes, Your Honor.
What year were you born?
First 24th, 81.
Okay, and the last 4 digits of your social security number.
6136.
Okay, you here on a probation revocation or pretrial diversion? What is he here?
We're just needing another negotiation day.
Okay, the negotiation day will be set for the 4th of next month. At 9 a.m. and then the next court date to the 11th. Where is he? Is this a revocation or is it just an indictment charge?
Revocation.
Revocation. So your attorney will be down to see you. They're going to negotiate about, see if they can work something out on your revocation on the 4th. They'll either have you brought up here or have a Zoom probably brought up here. And then on the 11th, you'll be back in court. Both of them are conditions, okay?
Yes, sir. Yes, Your Honor.
Now, we got someone here live.
Yeah, Megan Kennedy, Your Honor.
Where is she going?
Done, I think.
She was in treatment.
Yeah, Commonwealth versus Megan Kennedy. Are you Megan Kennedy?
Yes, sir.
You born in 1991?
Yes, sir.
What are the last 4 digits of your social security?
1034.
You're here on a pretrial conference. Do you need conflict counsel on this?
I do not, Your Honor.
Okay, so, you want to have a negotiation day on September the 4th?
We have a resolution on this
You
one.
do? What kind of resolution?
Felon plea.
Okay, I've just been informed the motion's been tendered, says she wants to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that was just
Yes.
identified here in Clinton Circuit Court,
Yes, sir.
case number 25 CR 0046.
Yes.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Is your judgment impaired today in any way?
Nope.
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes, sir.
You understand you do not have to enter guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept your plea, I need to know that you understand this.
Yes, sir.
You have a right not to testify against yourself. No one can make you say anything. Right to speak, trial, or jury, right to be represented by counsel at your jury trial. Right to confront and prosecute all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in favor. Right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove on reasonable doubt that you're guilty of charges against you. Understand? Yeah, but entering guilty plea, you give up all those rights. You understand that? And I
Yes.
consider the Commonwealth's recommendation, and that plain range of sentence provided. I don't have to accept the recommendation. Prior to accepting the recommendation, I will order a pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation?
Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, second offense, the defendant shall receive a sentence of 3 years, probated for 5 years, supervised. The defendant is currently enrolled in the Independence House in Corbin, Kentucky. Thus, she shall continue to remain in the rehab facility and complete it. The defendant shall obtain and maintain gainful employment when permitted by the rehab facility and continue employment once released from rehab. The defendant agrees to have any and all evidence of the above style case disposed of in accordance with the laws of the Commonwealth and the holding agency.
Is that your understanding of Commonwealth's recommendation?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment as amended? Is that correct?
Yes.
Doing so of your own free will?
Yes.
Knowing your constitutional rights and explain to us still your desire to give up those rights, enter the plea and allow the court to fix your punishment and range committed by law.
Yes.
You understand that after entering this guilty plea, future convictions will be enhanced as far as penalty. Y'all will let her listen to me.
I'm sorry, I apologize.
Sorry, Your Honor.
Is that your signature on there?
Yes.
Okay, we'll need a pre-sentence investigation for today. We'll need a pre-sentence investigation for it done and have her back here on September the 11th for sentence. Okay.
Okay.
And you allow her, where is it? You in a rehab now?
Yes, sir. I'm in, Independence House in Corbin, Kentucky.
Okay, well, we'll allow her to remain free on bond. As long as you stay there.
Oh, yeah, I graduated September the 16th.
Congratulations. I know it's sometimes difficult. If you leave there for any reason, you need to immediately contact your attorney. You should require the Commonwealth.
Okay.
Thank you very much.
Thank you.
Okay, now, is there anyone else? That concludes the criminal docket. Guess we're free till 1 o'clock, is that correct? Okay. Oh, yeah. Well, I didn't.
There should be an email asking me to continue.
Bring the grand jury.
I was calling right now, he's still in the docket, there's some job conference we did, or the.
Bring the grand jury.
I'm just all step right.
All right, so the grand jury. You can take your cap off. Okay, ladies and gentlemen of the grand jury. Everybody can be seated. The grand jury is seated. Who's the foreperson of the grand jury? Madam foreperson, would you stand? Have you completed your work? Stand
Yes.
again?
Yes.
Stand and stand again?
Yes.
Okay, have 9 or more of you agreed to the results you have there?
Yes.
Can you present it to the bailiff? You can have a seat. Okay, everything appears to be in order. If anyone's in custody, I will probably sign a summons for them to appear. If they're out of custody, we'll issue warrants with bond sufficient to protect the public if it's necessary or to secure their attendance. Once they're arrested, they'll be brought in and pretrial will interview them just to put the least restrictive requirements we can until they can come back to court here. The next time you're going to be in court is September the 11th at 9 a.m. unless you're called back for a riot or insurrection. Things seem to be pretty calm around Clinton County now. Not expecting any riots or insurrections, but you can't ever tell, you know. So you'll be subject to recall. Thank you for your service. I want to remind you that you're under continued oath to keep everything confidential you hear in there because it could be danger to people as they go out and try to arrest these individuals or maybe potential witnesses. That will allow you to come in here at 9 a.m. I hope you have a cool and collected August. Looks like we have some hot weather coming up. You're now excused. All rise to the grand jury and let's go off the record. Shelton versus Shelton.
Judge, we've submitted an agreed order electronically in that case.
Sloan versus Sloan.
Judge, we've also had an agreed order, we submitted electronically.
Cabinet versus Purdue.
Same in that case, Judge, agreed order electronically. And there's Stephanie's
Got the
cases.
auto pen, I feel like.
Yeah, oh, man. Well, then we get to Stephanie's cases.
Cabinet versus Kilburn.
Yes, in this case, this is an arrearage only case. We're asking that 500 be paid by September 10th of 2025, Your Honor.
Okay.
We submitted the order electronically.
Dickerson versus Ash.
Your Honor, if I need to put Stephanie under oath for this, it's a
For
default.
the testimony that you're about to give is true, whole truth, nothing but truth.
I do.
State your name.
Stephanie with them,
By whom are you employed?
Clinton County Child Support,
What is your position?
caseworker.
Are you familiar with the case we're hearing today, April Dickerson versus Michael Ash?
Yes,
Okay, and how are you familiar with this case?
I'm the caseworker.
Okay, and was Mr. Ash served in this case?
Yes,
And when was he served?
May the night.
This year?
Yes,
Okay, and to your knowledge, has a answer or response been filed in this case?
no,
How many children are there?
How was he served? By the sheriff, or mail, or what?
sheriff, yes.
How many children are there in this case?
2 children.
Okay, and have you figured up the amount of child support based upon the Kentucky Child Support Guidelines?
Yes,
And what is that amount?
$291 per month,
And when are you asking that that begin?
August 1st.
He's in jail.
Is he back in jail?
He's in jail. I don't see him in jail.
He was out.
Yeah, so he's back in now.
He's in custody in Tennessee.
Oh, is he in custody in Tennessee now? Okay.
Cornwell versus Carlton.
Okay, this is a default also, Judge.
For testimony about the future truth, the whole truth, and nothing but truth.
I do.
State your name.
Stephanie with them.
Are you familiar with the case we're hearing today involving Cornwell versus Sarah Carlton?
Yes,
Okay, and was Sarah served in this case?
yes, she was served June the 9th, 2025.
You know how she was served?
Wayne County Sheriff.
Wayne County Sheriff. And to your knowledge, has there been an answer or response received in this case?
No,
And how many children are involved in this case?
3 children.
Have you figured out an amount of child support?
Yes, we're asking her to pay $316 per month beginning August 1st.
And is that based upon the Kentucky Child Support Guidelines?
Yes,
All of this.
Submitted order sounds appropriate. So did.
One other one, Judge, it's Alvarez and it's an agreed order.
Thank you so much.
Thanks, Judge.
Okay, rest of the docket started. 1:15. Walk through.
Reno versus Carter.
Seventeenth, 161, Judge.
Very long docket.
Right. Agreement that everyone will receive.
Okay, let's go, we're on the record now. This is 17 CI 00161. Carter versus Carter.
Your Honor, Mr. Kincher's filed a motion. We filed a response this morning. He and I have met, and we are going to attempt to informally mediate this case before the next motion day. So I would think probably the best thing to do is just pass the motion to the next motion day and see if learned counsel can't hammer out an agreement on all this.
I think we can. I think the issues are, they may not be minor to them, but they're probably in the grand scheme of things, I think we should be able to work them out if reasonable minds prevail.
We want to put me out of business?
Yeah, you prefer that, don't you?
Yeah.
We're just trying to make your job.
I mean, I wouldn't have anything to do.
We're just trying to make your job easier.
Yeah.
And for future
Is there anything? I'm just reading last night about these non-medical procedures and 7-day notice on that sort of thing. I don't think that's very practical if you have 7-day notice for you have something. I mean, you need to have notice. Things can come up. So you're going to just try to work through those sort of details there.
Yes.
There's some issues about when the phone calls, that sort of thing.
There's issues on either side, and that's why I think we can work it out.
Okay.
I think the biggest issue, Judge, we're gonna have, if we can't work it out in mediation, just clarify snow days, how to deal with snow days, really. I think they have to let everything else worked out.
Anything we can't agree on, we'll submit to you, but if you just want to leave it on for the 11th.
Well, we can't, and if I don't get an agreed order by then, just schedule something on. Okay. I didn't really understand the snow day sort of thing. Where's the child go to school?
London, the old child goes to school here.
Okay,
But,
so if
Mr.
you have a
Carter's
snow
London.
day here, the parent that lives in London wants to have the kid.
It's like this, Judge.
Well, how do you get over there if you got a snow day?
Well, I think the thing is, if it's his weekend and there's a snow day, if he has the child on Sunday.
Keep the child over.
Correct. And
Okay, well, I can see here that we're gonna need a detailed agreement from these.
Oh, yeah.
It's not gonna be a lot of latitude because they're not gonna do so. Okay, thank y'all very much.
All right, thank you, Your Honor.
that's all I have, Judge.
Okay, yeah, safe.
Yes.
Let's go on the record. I have a Wayne Circuit Court case around the Special Judge Drake versus irrevocable trust. So Ms. Huff, are you on there? You.
Good afternoon, Your Honor. Yes, I am. We have
to this motion for extension of time.
No, you know, I think counsel for the plaintiff also wanted to do some additional discovery, so that's why we worked out the agreed order. We tendered that.
Submitted an agreed order, you electronically filed an agreed order.
I believe we did, Your Honor. Yes, sir.
Okay, so there's no reason to, if we see it now, there's no reason for you to linger then, so we'll go ahead and enter the agreed order, okay?
Thank you, Judge. I have one other case on the docket, so I'll stay on the Zoom. Thank you.
I didn't mean to run you off. Okay.
Thank you.
in the unofficial clock up there and the official iPhone, it's now 1:30, so I'll start the clock docket. First case on the docket is tax easing investment versus Denny, and I understand that motion withdrawn. Carter versus Carter has previously been held. McGall versus McGall.
My motion, Your Honor.
One White has a motion withdrawal.
Your Honor, it's our motion to suspend visitation based on the recent problems Mr. McGall seems to be having, and feel like he's not on the right path. I know he's made bond and out working now, but it's just not a good situation.
There was some limited visitation, structured visitation previously sometime.
Yes, his mother was supervised, that's correct.
And how's that going?
Well, right now, Your Honor,
No, not right now. He asked
Oh.
the visitation with Tammy supervised. That wasn't too bad, was it?
well, thing about it is, my kids were telling me that they was out riding around.
I don't want you to testify. I just want to ask you what's going on.
There were some issues.
Now, your lawyer is withdrawing. Ms. White, why would you possibly want to withdraw from a domestic case?
I've not been retained, and it's been some time since I spoke with Wesley. I think he's been incarcerated at one time.
Yes, ma'am.
I hadn't been able to reach him and not been retained.
Your Honor, our position with Mr. McGall is we hope he gets straightened out. He did well for a while. He went to rehab. I think it's a great motivation for him to do better, to withhold his visitation for a time being and see how.
I know you feel that way. He's without counsel here today. I don't know. I'm concerned. There's you talking about the EPO?
Your Honor, the main thing we're concerned about is these recent felony drug charges he's got.
I understand that, Mr. Cross. I read the motion.
Right.
You kick him again here. What?
No, we don't want to kick him at all. We just want to safeguard the kids.
I understand what the deal is.
Yes.
But we're required on occasion to order people to be taken to the penitentiary to do visitation,
Right.
I am, however, concerned about operating under the influence as far as the other controlled substances, resisting arrest sort of thing. How often have you been seeing the children? You didn't see them while in jail. When did you get out of jail?
February the 8th.
Have you seen the children
I've
since
seen
then?
them maybe about a week or so between then.
For a continuous week or what? That's when your mother had them or what?
Yes, sir. I ain't even, they blocked my mom, my
Well,
grandma,
I
my brother.
understand. Yeah, it's going. Mr. Cross, I'm gonna give him some time to get an attorney.
Okay.
Next month, but in the intervening time, if he conducts himself appropriately, I'm not against some limited time. If he won't talk about the case and he won't talk about the mama and he won't talk about anybody blocking anybody, kind of like a status quo situation. Now, is there anybody that's acceptable to you where the children, how old are the children?
Hazley is 12 and Weston is 9.
The 12-year-old you said didn't want to have anything to do
She
with
does
it.
not want to go.
Yeah, well, of course, I can understand that, but it's not her decision. Whether she goes or not, I don't want to force anything, but she needs to be coached up a little bit. Is there anyone that'd be acceptable to you that's an aunt or a great aunt or somebody like that where you would feel secure for the children being there a couple of hours?
Delbert Redmond. That would be the only one.
Who's
that?
that?
That is the kid's step grandfather. He's the only one that would
I
actually.
didn't understand the name. You talked faster than I could hear.
Redmond.
What was his first name?
Delbert.
Delbert Redmond. And I don't know Mr. Redmond. That's my stepdad, so.
Okay, well, why don't you see, Mr. Cross, why don't you get an order? Are Saturdays good for you, like a little time on a couple of hours on Saturday morning or something like that, or is it?
9 to 11, 10 to 12 on Saturday.
Okay.
What's the 10 to 12 on Saturdays at Delbert Redmond's house? Yes, sir.
Okay, if he'll accept it, if he won't accept it, the visitation, then we'll have to revisit that. So
He won't.
Yes,
if
sir.
he
I'd
won't
just
do
like
it-
to see him.
If he won't do that, let me know.
Yeah, he will.
Okay,
He will.
okay, 10 to 12
Okay,
on.
now, here's the deal.
Yes, sir.
I don't have to tell you, you come there, not under the influence of any drugs, no alcohol. And there's a status quo, you just tell the children you love them and you're glad to be there. And if the little girl is a little sensitive right now, you just need to go along with that.
Yes, sir.
You know, for whatever reason, I don't know the whole story, but it's hard to see your go to jail.
Yeah.
When I used to, back before COVID, when I used to visit jails all the time, that was a primary concern of the people in there. It's what they'd done to their family. Now, they weren't concerned when they did it, but so let's get an order and, start it this Saturday at his house.
Yes.
Would it be better 9 to 11 or would it be 10 to 12? Which one do you?
Well, Your Honor, my schedule at work is a little bit, days and nights, but my father would be the one, taking the children because I have a DDR lesson.
Okay.
And I do not want to be nowhere near.
What's your address? What's
Am I
the address? 21 McFall Road, so.
Let's do every other Saturday.
Okay.
And your father will transport.
My father, Bruce Stearns, or my mother, Sherry.
You want to start this Saturday, is that okay? We'll start this Saturday.
Now, let me tell you. If there's any problems, it won't be good.
Yes, sir.
Okay?
Thank you.
Okay, and then,
We'll start this Saturday, you'll get a copy of this in the mail.
Ms. White, now that we've got that going, you want back in this case?
I don't think so, Your Honor.
Okay, well, I'll sign your order to withdraw then. Reluctantly, I know you.
Thank
You need to lawyer up in the next 15 days, lawyer up, and then y'all can reschedule any motions for the next real day, okay?
Yes, sir.
Okay, thank you very much.
Okay, good, I'll talk to you all, just don't leave. I'll
You
talk.
let him go on out and then they'll follow it.
Yeah.
South Park. Mid-South Partners versus Winkle. Motion Lee, for filing an amended complaint. The motion has been been withdrawn and there seems to be no opposition. So they can electronically file an order, we'll allow them to amend. LVNV funding versus cost. Motion is withdrawn.
There's supposed to be an agreed order dismissing on that, I don't know where it is.
I think I saw it. So you just received a notice, maybe a hard copy. Make sure it's been filed. You involved in that case, Mr. Cross?
I'm sorry, Your Honor.
Are you counseling that
Yes,
case?
for
You make
Cross.
sure that the order's been electronically submitted or filed, okay? Paula Pickens versus the Medical Center in Clinton County.
Good afternoon, Your Honor. Ellen Grimshaw on behalf of the defendant.
Good afternoon, Judge. This is my motion to compel, but I would like to state, we are going, at this time, I'm going to ask to withdraw my motion on
Okay, well, Go
yesterday.
ahead and just sit on down there.
Okay.
No, while I've got you both here, I'd like to discuss this a little bit. This is something that happened on the property and was not a medical malpractice situation, is that correct?
It is medical malpractice. Yes.
There was one in here that was a slip and fall.
And that is this one, Judge. It was a slip and fall, but then our argument is he wasn't properly treated, which resulted in his
I
death.
couldn't tell really, I didn't have the file with me as I was reading it. And I couldn't tell, so you had a slip and fall that kind of morphed into a malpractice situation.
That is correct,
And
Judge.
then, of course, some of the objection to discovery was, the statutes and regulations that keep you from interfering with internal review of those sort of things. Now, I didn't know whether in the future, you need to differentiate between records that, in my mind, it would help if you have to come back, differentiate between the records that actually went to the injury that was involved, or if you're deposing people that were employees that saw the fall, or those that were involved in the treatment, because you really got two separate things. I mean, do you have a cause of action for the fall too? Was it one that was out in the parking lot or somewhere, or what?
He was in his room.
In his
He
room.
was, yeah.
There was another one out there that I read of sometime. That was the dollar store. I got the dollar store in a hospital. So, okay, so y'all are making progress on what's discoverable, what isn't discoverable now.
We received an attached affidavit from defense counsel yesterday, and up until that point, we had never saw anything that was in that affidavit. So from my point of view, we were going to depose, it was the risk management affidavit. We are wanting to depose him. I think we need to depose a couple more nurses and staff, and then we may have to file a motion to compel at a later date, but
See if you can break the shield sort of thing.
that's correct, Judge.
So you're glad to leave now also, is that correct? You don't have anything else?
I do not.
Okay, thank y'all very much.
Thank you, Judge.
Flowers versus Commonwealth Life Insurance. It's a reorder that's been withdrawn. Sentinel versus Longwell. Hello.
So our motion regarding foreclosure and sale, this court's already entered a default judgment. We waited a period of time to see if that could be resolved. It's still to be resolved and then filed with the courts or with the property.
I see where there's a motion for summary judgment in here too. Is this an in rem that you?
Yes.
Had so. A lot of times, sometimes people, or as I used to try to force judgments out of state, some people rather have a summary judgment than a default judgment because you can get enforced in other states, but you just got a straight up judgment. What was the nature of this?
So essentially there was two people that owned the property.
Yeah.
And my client was paying the taxes on it.
Yeah.
However, the deed that was filed first to the courthouse, so the other individual has ownership to it, has never done anything with it nor upkept it. So my client asserted he bought the taxes that were not paid and is moving to foreclose on it to get it for sale, get obviously his money back.
Rather than go the indivisibility route.
Yes.
So this way you can collect the taxes, unpaid taxes.
Yes.
Okay. Never answer filed by anybody.
No. And we do have service process.
Electronically submit your order, we'll say. You submit an order?
I think there is an order already submitted. I think my staff did that, sir.
Okay, glad in it. Thank you for your
Thank you.
patience.
Have a great day, sir.
David Cross, signing of Bluegrass Cellular versus York Farmers Velocity, Clinton County, City Alderman, Barbara, unknown mayors and things.
Your Honor, I think we've sorted this
Give me a
out.
thumbnail. I read your motion. And in the motion, you made me feel better because you said it was something that was hard to understand and I was.
It's crazy, Dave.
Yeah.
I didn't write it, but anyway.
What resolution? Is it?
Well, Your Honor, the bottom line on it all is there's $1,550 and I think 3 cents that needs to be paid to somebody. And we have a affidavit from Barney Latham and I think it's been tendered by now, it's supposed to have been. It says Barbara Daniel has made the payments and she's paid the taxes. We want to see about paying the back taxes. And she's paid them all. So Barbara Daniel equitably needs that $1,550. And I think what I've tendered to the court reflects that.
Have you had, as a master commissioner, had an opportunity? to
Yes.
review that?
Yes, Judge, and my only question is when the date of the interest stops is My understanding, it was at the time of the sale. And I have figured the difference between Mr. Cross's numbers versus my numbers, which stops the interest at the time of the sale. It's a very de minimis amount, roughly 30 some odd dollars. However, I felt the need to kind of question that.
When I was master commissioner, we figured it through when the time they got paid. It's not like a bankruptcy. It's not totaled for anything. That's my understanding, but.
Well, we'll let the $30-something slide this time. If it gets up to 40, it'll be a different deal.
So does that mean I get the extra 30 some odd dollars?
Yeah, I wouldn't.
I'll be audited on that.
I'm hoping I don't have to regraph what's
I hope
been done.
that this, so there's nobody objects to this.
Everybody's in default.
No. This one feels a little funny.
Well, it's a weird deed and a weird transaction.
Okay.
I'm glad to get it cleaned up and out of the way in the neighborhood. That's all my goal was. A nightmare.
Okay. So, hopefully the public service.
Yes, thank you.
Wilson versus Thrasher. Agreed order going to be tendered, I understand.
Yes, Judge, I've been with Mr. Garman and we have a temporary agreement.
Okay. Bean versus Eddie K. Jarvis. Who represents Mr. Jarvis is in jail. Who represents Bean?
I believe Mr. Poindexter. Mr. Barnes.
Let's see. Is Mr. Poindexter still here?
I think they're gonna do it very order.
Will we announce Bean versus Jarvis? Heard rumors that there's agreed order, we'll pass over it. We'll get to Phyllis Hay versus Dollar General Corporation. Motion's been withdrawn. Lampa versus Sun Pools and Sunshine Installations.
Good afternoon, Your Honor. Shelby Sanford on Zoom, appearing for defendant Sunshine. Oh my goodness, if I could talk. Sunshine Installations.
Your Honor, Winter Huff, I'm here on behalf of the manufacturer, Sun Pools Incorporated.
I'm here for the plaintiff, Your Honor.
And I'm local counsel for the defendant.
Well, I read this last night a couple of times. Mr. Brown, Judge, what is your belief about this arbitration clause in the contract?
Well, we do not actually have an objection to an order of arbitration.
Okay, well,
the issue that we have, Your Honor, is that the defendant, Sunshine, has filed a motion to compel and said that they wanted an order to compel arbitration and dismiss the proceedings or stay the proceedings. They tendered an order which said the case would be dismissed. I'm just asking for the case to be stayed.
Well, let me ask you, I never have done, if these arbitration clauses are like this, why doesn't everybody have an arbitration clause in the contract of the court system? I just thought you might come up with some good public policy situation where I would rule it would be unconstitutional or something, but I guess that would always left to Franklin Circuit Court to enter such momentous sort of decisions.
I'd love to, Your Honor. I'd love for you to hear this case, but I've done the research and I don't think I can prevail.
Reluctantly, I'm going to have to miss the first portion of it. Now, what is the appeal process if people don't agree to arbitration? Is there an appeal process? Is it binding arbitration? And Mr. Cross?
I defer.
Ms. Huff, what do you think?
I defer
Ms. Sanford, I'm sure you think it's binding arbitration,
Yes, Your Honor, I would say so.
unless you come up on the wrong end of it, and then you might, so don't box yourself in. So, who's the arbitrator gonna be? And they chosen from that arbitration group? The reason I want to do it because it's hard to get all y'all together, and it might advance the resolution, even in arbitration, if you tell them who the arbitrator, you know who they are?
No, I don't, Your Honor. I figured that once the order would go down, that I would contact the AAA and go through that procedure.
Okay.
Your Honor, if I could be heard, my client has a little bit different position in this. Sun Pools Incorporated is not actually a party to the agreement that contains the arbitration provision, but the arbitration provision does include claims against the manufacturer, which would be my client, does indicate that those claims would be arbitrated. So I think our role is really more, we are a material witness, we are a third-party beneficiary, but I don't think in and of itself, because we're not party to that contract, I don't think we can be compelled to arbitrate. I will represent to the court. Obviously, it's in our interest for this to be resolved. We will cooperate.
And Your Honor, if I may briefly be heard as well to answer your question, we don't have a specific arbitrator selected, but the arbitration provision does say that the final arbitration hearings would be held in Clinton County. So we do have that, but we don't have a specific arbitrator.
Well, Wanda White's attorney here, she just got out of a real rough case a while ago. We could volunteer her, but I don't, would you like involvement?
I wasn't listening to the facts, I've been back and
Oh,
forth.
okay, well, she's not interested.
You can't do this.
Okay, well, thank y'all very much. And I'm not gonna dismiss it. I'm gonna put it in stay just because one of the parties might not be subject to the arbitration, and we'll get it. Save y'all another filing fee.
Thank you, Your Honor.
Okay, thank y'all very much.
Thank you, Judge.
Thank you, Your Honor.
This is y'all. This is- Yeah, Diversion, Don Jr. Yeah. Claiborne versus Catherine.
Can I speak to Mr. Cross for 1 second, Your Honor?
Yeah, we might get this worked out. We need a few more minutes, but I've been kind of on hold on the case with this.
Okay, we'll pass over that just for a second. Anderson versus Anderson.
Your Honor, I am here on motion to withdraw as counsel for Ms. Anderson.
She's already staying.
And she's retained new counsel, Holly Coleman, entered an appearance a couple of weeks ago.
Ms. Coleman, are you on there?
Yes, sir, I'm on here.
Okay, is there any other motion to be heard in this case other than your motion to withdraw?
Of which I'm aware of.
No, Judge, Ms. Coleman and I spoke this morning, and we're hoping to get a resolution soon.
Okay. Submit your order electronically.
I did, Your Honor.
Okay, we'll sign it.
Thank you, Your Honor.
Midland Credit versus Gillen.
Lisa Riley for the plaintiff, Your Honor. That's our motion for default judgment.
This is a PayPal credit. This is a PayPal credit case.
Yes, I believe so, Your Honor.
And was this, I just kind of wondered how that worked, you know, I used to do PayPal. So this person did PayPal and didn't pay PayPal. Is that what happened?
Correct. There was a default on the account.
I just didn't know how PayPal worked. I mean, you know, the person that uses PayPal pays PayPal like I would a credit card, right?
That's my understanding on this account, Your Honor. We included the account statements.
I'm sorry, I can't hear you.
Yes, we included account statements, Your Honor.
I have it here. I just never have seen a collection action by PayPal, and of course, y'all, Midland Credit bought this account. Is that what happened?
That is correct. That is correct.
Okay, well, it appears that all is in order here. Did you electronically submit an order to us, did you?
We did, Your Honor.
Okay, well, we'll sign it. Thank you for your patience.
Thank you.
Britt versus Britt.
No, it's on, yeah, and I'm here for Mr. Wittenberg. That's his motion, that's the final hearing in the case.
Are you Austin?
Yes, sir.
Do you have an attorney?
No, sir.
Well, I have, Mr. Wittenberg said he had a funeral today or something, is that right? I don't know what issues are to be tried. Do y'all have children?
Yes, sir.
How many?
I've got one more.
Okay, and you have any property?
No, sir.
Okay, do you have any retirement accounts or anything?
I did have a possible. Sure, that's the year.
I do. I do.
Both of you do?
I do.
What
I
is
do.
there, y'all know, since you're represented by counsel, I can talk to you, what is there left to be decided in this case?
Just I guess the final hearing, just.
Well, I know, but I usually, if I have a hearing,
Yeah.
if there's nothing to decide, I don't have a hearing. So what are you in disagreement about? Anything?
No,
How about child custody, child support, anything like that?
no, we've already worked through that.
You did a good job. Good.
Yeah, well, why don't you get Mr. Wittenberg to just submit me an order?
Okay.
And both of you have to go through those parenting classes, I guess.
I've already taken that.
You taking your parenting class? Well, you need to take your parenting class as soon as you can, because you're not gonna get any visitation till you do, okay?
Yes, sir.
So did the county attorney calculate the child support?
Oh, yes, yes, sir.
Okay. You're satisfied with that calculation? Well, just tell your attorney to submit a proposed judgment and send it over to Mr. Britt, and I'll go ahead and enter it without y'all having to come back.
Yes, sir.
Okay, thank y'all very much.
Thank you, Your Honor, that's all I have.
Kathy versus Connor. Kathy versus Connor. Ms. Coleman, you're on the line here. We can see you.
Yes, sir.
Yeah, defendant had 30 days to obtain counsel and file an answer. And the plaintiff had 30 days to brief all issues as far as estimate of loss. Now, have you got us an estimate of loss?
Are you speaking to me, Judge? Judge, I filed a brief, I guess a memorandum in support of our stance.
Did you predicate your loss upon what, on the $8,000 and tripling it? Is that what you did, or?
Yes, I mean, barring any sort of proof from Mr. Connor that it's other. I know he spoke in court last time and indicated a different amount, but we've not been provided anything that would back that up. So I didn't appear in person because I had a message from an attorney there who had asked if I would agree to give him a little additional time to hire an attorney.
Who was the attorney?
I'm sorry.
Who was the attorney?
It was Norb Sohm. I've received communications from, I think, almost every attorney in Clinton County at this point. None of them represent Mr. Connor. They're just, I think, reaching out on his behalf usually.
Yeah, I want Norb here. I want to find out why an attorney's calling somebody that hadn't entered an appearance in the case and wants an extension of time. That's not cricket to me. We'll find Norb and bring him back up here and see what Norb is doing. I read the deed that was attached. And in my opinion, as soon as you file an answer, there's going to be a summary judgment issued against you. Because you have no right to go in and cut timber on a piece of property that you have a life estate on. So that, yeah, so I don't know, you need to get somebody, but have you filed a motion for summary yet?
I have not, Judge. I was trying to, give every courtesy to Mr. Connor if he needed a
Well, I
little
tried to
additional
give you
time.
courtesy too. I gave you 30 days to get a lawyer. You hadn't gotten one. And then to have Norb or somebody call up and say that he wants an extension of time for what? I mean,
And I'm not trying to throw Mr. Soam under the bus. Like I said,
You already have, you're not trying to, you already have gone, so.
I'm just explaining why I didn't come in person because I assumed that the court would probably give Mr. Connor that time if he asked for it in person.
Why don't you have an attorney?
I've been trying.
Well, look, there are a dime a dozen there. There are attorneys everywhere around. I'm gonna tell you, you're gonna have a hard time. I've known you, I've known your family for a long time. You can't make me believe that you didn't know what the game is when you have a life estate in timber. Y'all been around the oil and gas business and timber and everything, but I'll let you come up. You need to get a lawyer within 10 days and file an answer. And I really ought to, if there was a motion for summary judgment, I'd enter it today because you've had this time to get, you'll have a hard time getting anybody to represent you on this case because there's no defense to it.
I just want someone to hear it. I did not want that money for myself.
What?
I was trying to improve the property. I thought I had the
But
right.
you can't improve the property by selling timber off of it. And,
property-
and when you go start cutting down trees and things like that and selling it, that invades the remainder of its interest.
Yeah. It's only 19 acres cleared, 27 acres, it's not cleared. The land would be worth so much more if it was cleared.
Well, you get an attorney and file an answer. Get an attorney. I'm gonna give you 10 days to get an attorney and file an answer. And if he doesn't file an answer within 10 days, Ms. Coleman, send me an order for default, okay?
Yes, sir. Yes, sir.
Anything, okay? Thank you very much.
Thank you, Judge.
Spear versus Elmore.
Your Honor, I see Debbie Elmore is present and ought to come up. Kim Elmore, as my response or my notice to the court states, is incarcerated in Russell County, I presume. We do have one of the guardian ad litems here, but quite frankly, it seems to me Kim's got to have a guardian ad litem. And I don't know what we can do until that happens.
Well, what is the underlying motion?
Well, you wanted to review it today.
Yeah,
Scotty's
I
got
wanted
the
to
kids,
review, and I
everything's
wanted
good.
Apple Red, somebody to contact Apple Red.
Well, they're not gonna represent her. She's in jail. They're not gonna do that. She's been in jail since this happened. She's gotta have guardian ad litem.
Well, I know she does, but I'm trying to find out where we are in the case, Mr. Cost. What do you have to say about this?
For right now, Judge, the kids are with dad. Kids are doing very well.
Who do you represent? Dad?
Yes.
Mom still doesn't have representation.
No, because she's been incarcerated for what, a couple of weeks?
What's she incarcerated?
Drugs.
So are you guardian ad litem for the children?
That's correct, Judge.
So I will appoint a guardian ad litem. Who's next on the list for him? And once after, you have a list?
Yes, from King.
I already did that.
On July 2nd.
Who?
Yes, from King.
That's it. I was appointed for the children.
Children.
So who did the mother?
You know
They look for
her,
the mother.
she's Oakley daughter.
I nominated Miss Sawyer, but she's in one there.
Yeah, Miss Sawyer's look like getting
No
involved.
one wasn't one. I think no one was appointed. Okay. I'm gonna go get the list.
We'll see who's lucky enough to be next up on the list. Perhaps it could even be Wanda White.
She's unloaded a lot of her dollars.
Yeah, she's got free time. We know she's got free time.
My free time's waiting on Mr. Cross to get it done, so
He loves to tell that story about Bill Dabney, who said he declined an appointment. He had a long deed to write.
Well, in the old days, maybe some of those people, it took a long time to do it, so. Which are pretty powerful. Who's next? Holly Perigin is next step. Congratulations, Ms. Perigin.
Well, thank you, Judge. Appreciate it.
Going in an order today appointing you to represent the mother who is
Kimberly.
incarcerated.
And this is her mother, so that's.
Yeah.
Okay?
That's good.
Thank
Thank
you
you,
very
Your Honor.
much. Yeah, thank you.
Thank you.
Wait for me outside. Your Honor, could Ms. White and I revisit that Claiborne and Catherine thing? Because we're not getting an agreement. I think we're going to have to let you tell us what to do today.
Okay, Ms. White, you want to come? What's the deal now?
We were here, I think it was August, and we started visitation for July. My client has been visiting this child, Wednesdays from 5 to 7:30.
Somebody coughed and I didn't hear your whole sentence. Speak up.
Every Wednesday from 5 to 7:30. And his other visit on Saturdays was 12 noon to 5.
Okay.
And we came back to try to negotiate an extended period of time, and we're unable to reach an agreement. My client has proposed that on the Saturdays that he have the child, that he keep the child overnight until Sunday at 4.
And in
How
response,
old is the child?
Is she 2?
in response, Your Honor, we realize Mr. Riddle's going to be getting some increase in his parenting time. We think that the acceleration of it is a bit hasty.
Do you think you'll have grounds that he doesn't get 50%?
Well,
That's
possibly.
where you're headed if you don't reach an agreement,
Possibly.
unless there is something to overcome those factors in it.
Well,
That's just, I don't necessarily agree with that law. It's just the way the law is.
I know, and it sort of remains to be seen how everything goes, but at this point in time, they're not agreeing to any overnight. What we would suggest,
Who's gonna be with you if you have the child?
He lives with his mother, and his sister is present also. She's an adult.
He's an adult also.
Yes, he's an adult. He works.
See, you have any
very
criminal
responsible.
record, any drug record or anything? Where do you work?
I want to crack marriage, construction job.
Y'all need to go back there and reach some kind of agreement or I'm going to.
Well.
This was our proposal,
we tried,
thinking
Your Honor.
and
I think
asking.
Give me a proposal that would be.
Our
for
proposal
temporary.
was that I told Mr. Cross, we would agree right now to keep the Saturday visit from 9 to 6. And every other Saturday, do Saturday at 9 to Sunday at 4. And just
Okay.
review it in
and
2
that-
months.
That his mother or sister will be present.
At all times for transportation and everything.
Well, I don't know why they should be for transportation, but I'm talking about for overnight. You know, it's a little girl.
Yes.
See, I'm a little sensitive to putting little girls anywhere where they haven't been before. Not that I'm prejudiced against little boys, but you know, it's just a different, in my experience, that the adjustment's a little bit different sometimes. You know, do you have a booster seat? Okay. Well, I want to make sure that's in the order that anytime the child's transported to booster seat. And where do you want the child picked up?
Well, we thought Page's Grocery on the Saturdays, and on the Wednesdays, we thought maybe the police station here or 911 center.
What's wrong with Page's Grocery all the time? Is that,
Because the Wednesday visit is only like 2.5 hours.
where does he
And
come from?
he lives in Burkesville, but he has family here, which is.
Why Page's, Burkesville, just a hop and a skip in Burkesville.
He's willing to do that. We
Well, let's
just,
just keep it at Page's. That's about halfway between here and there.
So his Wednesdays moving to his mother's, because it was Eric Riddle's.
Well, it's whatever the order says now. That's not been discussed, so it's whatever the order says.
he may continue, but we would just like to lift that restriction, but he may continue.
Where do
to
you
do
want
so.
the Wednesday night visitation to be?
I like it, the place.
He would like to do it at the police station in case he wants to
No,
go to.
when he's got the visitation,
The location of the.
where's he gonna be
wants
with
to
his
be
child?
able to either visit his family here or take the child to eat or to Barksville, the park.
I don't see a problem with that on the Wednesday. It doesn't have to be, but when the overnight is, I wanna know where the child is.
The child would be at his home in Barksville with his
With his
mom.
mother or sister there.
They reside with him.
Okay.
And could we review this in a couple months?
Well, hopefully you'll have an agreement by then.
We're trying, but it's
Well, I
been,
mean, I'm not gonna give up on it for a couple of months, so I'll let you redocket it. I'm expecting an agreed order. You know, you know, this is not a situation where I'd rather have this or I'd rather like that. I'd rather have an agreement. I don't wanna have to make these decisions. But y'all are gonna have some serious conversations with your lawyers, both of whom are experienced practitioners, and they know where this is probably going if you don't reach an agreement. Okay, thank y'all very much.
I will.
Sure, I think that's all I have, if I may be excused. Thank you.
We would ask that the Saturday overnight start this weekend.
Whatever he says.
Yeah. Asset security versus WW.
Afternoon, Your Honor. Tom Ezel for the Petitioner Asset Security Consulting, and I believe the WW is Wade Wilson who's here. Wade Weston, I'm sorry.
And Your Honor, Joseph Kramer appearing on Zoom on behalf of Mr. Weston.
This is a structured settlement transfer.
Already.
Mr. Weston, not only as counsel, he's consulted financial advisor, seems to know what he's doing, and we can proceed with.
Mr. Weston, is that correct?
Yes, sir.
WESTIN. Where did you get Mr. Kramer? Where'd you meet Mr. Kramer?
Mr. Kramer, I looked him up online.
Yeah, so you made an independent contact and the company
Yes.
didn't line them up for you, right?
No, I just looked at him, yes.
You what?
I looked at him on the internet. I looked at several of them. He is the best one for the job.
Mr. Kramer, are you convinced your client knows the costs involved in doing this transfer and assignment?
Yes, Your Honor.
Okay, well, just submit it and I'll sign it.
I will submit an order, haven't yet, but I will do that, Your Honor. Thank you.
Thank you, Your Honor.
I used to try to protect people from these things, but it's beyond my ability to do that, so.
I think it's worthwhile to make sure they have lawyers and financial advice
Yeah.
at a minimum.
Okay, thank y'all.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, is that the entire docket? You know, we have an EPO. What time is that scheduled? So we're ready to go on that? Stacy Gail Byers Smith versus Robert Matthew Taylor. Come on up here, everybody, come on up here. Everybody, come on up here.
Your Honor, can I grab my child real quick? It's down in here somewhere.
They wouldn't let you on a Delta flight with all that luggage there. Okay, Stacy Gail Byers Smith, is you, correct? And you're Robert Matthew Taylor Smith.
Yes, sir.
Okay, what do y'all have here?
Your Honor, my clients, filed for a domestic violence petition. I think it was June 5th of this year. It was set in front of Judge Lawson. A motion for continuance was filed. It was set in front of Judge Latham. And 15 minutes prior to the hearing, they filed divorce. So it came before this court and they asked that a GAL be appointed, which the court did, that's Ms. Sawyer's. And that's where we are today.
And sorry if you had an opportunity to examine the situation underlying facts.
I read all the pleadings.
Will you come over here in front?
I'm sorry. Yes, Your Honor, I've reviewed all the pleadings, both in the domestic violence case as well as the counter motions for temporary custody. I have spoken with Ms. Byers as well as Mr. Smith.
Yeah, this typed addendum to the petition motion for order of protection was not the normal sort of thing So usually you go to the clerk's office or somewhere and they write out this was a type thing. It was really pretty hard for me to follow. As far as specific allegations are concerned, what I got mainly out of it was the accusation that Mr. Smith has been physically punishing or slapping the child. Was there allegation that he did anything to you?
I had leg breaks on me from floor, but
Well,
there was allegations, Your Honor, of the threats.
Yeah.
Well, not the EPO, I think they, in their motion for temporary custody, they mentioned something.
I'm looking at the motion for order of protection.
Yes, Your Honor, she made allegations of threatening statements of blowing up the vehicle, burning the house, and making comments to her up close in a threatening manner. I'm looking for a petition.
I was just thinking that there was nothing stated there that he actually physically made contact.
He's gonna blow her up.
Well, that's the allegation. Be fair, the allegation doesn't say that, it says, well, car.
Yeah, I have no proof of that, and I understand. Okay, is this a situation where there can be a restraining order entered, or do you want to have a hearing on it? We can have a hearing if you want to. I'm not trying to force you on it.
I haven't had any direct communication about any type of offer from Mr. Bell. My client is in fear. But I understand what you're saying. I'd be willing to talk to her and Mr. Bell if he wishes.
And I'll kind of be upfront, Mr. Smith. If the order, these two not have contact, then he's got no problem with that. Of course, we've got the ancillary issue of the custody and visitation. You know, we'd like to try to get something in place for that. If the order is you two not have contact, my client has no problem. He has no desire to have contact.
I would have to speak to my client.
Why don't y'all step out and speak to him about any potential visitation, this on a temporary basis? And then I'll get what you have to say about it when we come back.
Okay, thank you, ma'am.
Okay, let's go off the record. That's the last case. Well, we had all those on the docket today, it's just running through a lot. Shouldn't give up.